silent ಆಗಿದೆ. ಬ್ರೈಟ್ನೆಸ್ ಇಲ್ಲ. ಹೌದಾ? ಬ್ರೈಟ್ನೆಸ್ ಇಲ್ಲ ಇದ್ರೆ ಅಲ್ವಾ? ಸ್ವಲ್ಪ ಮಂಗಳವಾರ ಬರೋದು ಒಂದೇ ಸಲ, ಒಂದೊಂದು ಸಲ 2 ಸಲ ಬರ್ಬೋದು. ಬೆಳಗಿನ ಸ್ಟೇಟಸ್ ಹಾಕಿದ್ದೀನಲ್ಲ, ಹೇಳಕ್ಕಾಗಲ್ಲ ಸರ್. ಯಾವ್ದಾದ್ರು ಬೇಗ ರೀಚ್ ಆಗ್ಬೋದು. ನೋಡೋಣ ಅರ್ಜೆಂಟ್ ಎಷ್ಟಾಗುತ್ತೆ ಅಂತ ಡಿಸ್ಪ್ಲೇ ಬಿಟ್ಟು ನೋಡ್ತಾರೆ ಹೋದ್ರೆ. ಉಪವಾಸ ಏನು ಮಾಡಿಲ್ಲ, ಪೂಜೆ ಮಾಡಿಲ್ಲ. ಸಂಜೆವರೆಗೂ ಆಗಲ್ಲ. Any memos?
Memos.
Your Lordship, kindly, this is a criminal appeal, my Lord, which was disposed by this court, my Lord. It is with respect to Electricity Act, my Lord. And while disposing the criminal appeal, your Lordship has given liberty to the appellant to deposit, to pay, to compound the offence, my Lord. As per the order passed by this court, we have compounded the offence by paying the compounding fine before the trial court. And the trial court has accepted the compounding fine but failed to acquit the accused on the ground the appeal, the Honorable High Court, while disposing the appeal, confirmed the conviction passed by the trial court. So unless there is a special direction from the Honorable High Court, I cannot.
Offense is already complete.
Yes, ma'am.
You have already committed that.
Yes, ma'am.
Then,
but at any
compounding of the offense at this stage will not absolve you from.
There is a direct Supreme Court judgment on an identical issue, and at any stage, even if the accused is in custody, also on payment of compounding fines, he should be released forthwith.
But during the pendency of the appeal, you never compounded.
Yes, my lord.
Then,
so even while undergoing sentence, also I can compound.
File it. No, I don't know. File it. Let me consider. Have you served the copy on the other side?
No,
Please serve the copy.
That application I have served to the.
Serve them. Otherwise, I will not take up.
No, I have served the copy, which has already filed by me. This is only a memo.
Yes.
Any adjournment?
My
Page
lords,
4, serial number 17.
One mention, my lords. This is a 2022 criminal petition. The investigation has been stalled for the past 3 years, my lord, and for respondent number 2 in this matter. We are being aggrieved by this because we cannot proceed further.
Serial number
17 to
Serial
21.
number 12,
Any adjournment?
Serial number 18.
12. No, serial number 12.
Serial number 17 to 21.
Serial number 18, madam.
Serial number 17.
18
Since
yaru.
Serial
Lordships, serial number 17. My senior is unwell. I'm seeking for an adjournment, Your Honor.
Go for.
A petitioner, 1 and 2.
So why there are
Yes,
two
Raj.
advocates, Dayamani and Rajshekar? You are representing whom?
A petitioner number 1 and 2 in this case, Your Honor. We have filed an NOC wakalat.
No, only for petition number 1 and 2.
Yes,
3
Your
and
Honor.
4, somebody else is there. Dayamani. Yaru.
Dayamani?
serial number 34, my lord.
Number 1 and 2, praise for time. Counsel for petition. Number 3 and 4 is absent. There is no representation. The petition is of the year 2018. List finally as elections. Finally posted. Next. Yes. Next.
Page 5.
Lordship, serial number 22. Appearing for petitioners, Lordship.
Hmm.
Serial number 22.
Yes.
Kindly have this matter next week, my Lordship.
The same thing. Finally as elections. Yes. Next.
Much obliged.
24, madam.
20.
24, madam. They seek for 1 week's accommodation.
24.
Please.
Yaru.
They seek for 1 week's accommodation.
Idu hage. Finally. Hmm. All
For the
these-
respondent, my lord.
All these are listed finally. No further agenda.
29 also, ma'am. It's 29, my lord.
Page
In
6.
serial number 29, my lord, I am for the respondent, my lord. ಅದರಲ್ಲಿ ಸ್ಟೇ ಏನಿಲ್ಲ ಜೊತೆಗೆ ಟೆಕ್ನಿಕಲ್ ಇಶ್ಯೂಸ್ ಸೀಸ್ಡ್ ಇನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ವೆದರ್ ಸಿಸಿಬಿ ಹ್ಯಾವಿಂಗ್ ಎ ಜೂರಿಸ್ಟಿಕ್ಷನಲ್ ಪೊಲೀಸ್ ಆರ್ ನಾಟ್ ಅನ್ನೋದು ಇನ್ನೂ ಅದು ಇತ್ಯರ್ಥ ಆಗೋ ಸ್ಥಿತಿಲಿ ಇಲ್ಲ ಅದರಿಂದ ಸೊ ಅವರು ಚಾರ್ಜ್ ಶೀಟು ಹಾಕಿಲ್ಲ ಸೊ ವಿ ಆರ್ ಇನ್ ಡೈಲಾಮಾ
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ
ಏನು ಇಲ್ಲ ಸೊ ಲೆಟ್ ದೆಮ್ ಫೈಲ್ ಎ ಚಾರ್ಜ್
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ ಪಿಎಸ್ಒ ಗೆ ಸೆಂಡ್ ಮಾಡಿದೀವಿ ರಿಕ್ವೆಷನ್ ಸೆಂಡ್ ಮಾಡಿದ್ವಿ ಪಿಎಸ್ಒ ಬರಬೇಕಿದೆ
ಲೆಟ್ ದೆಮ್ ಫೈಲ್ ಎ ಚಾರ್ಜ್ ಶೀಟ್
ಎಸ್ ಪ್ಲೀಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್
File ಮಾಡಿ and report it to the
Aಷ್ಟೇ.
court.
Yes, please,
then
your
you can go through it.
Yes, please.
Yes. Counsel for the petitioner and
Serial number 34, my lord.
Your Lordship, serial number 26, Your Lordship.
learned counsel for respondent number 1. Please come to produce the final report that is to be filed by the investigating officer before the trial court. Next. Yes, serial number
Your Lordship, serial number 26, Your Lordship.
32.
My lords, requesting 1 week time, my lord, our senior is out of station.
Finally as a last chance. Next.
My lord, interim order may be extended.
Finally posted.
Please.
No further agenda. Yes, 26.
Your Lordship, serial number 26, Your Lordship, kindly pray for some time for hearing.
Long day. Yes, next.
Serial number 34, my lord. Serial number 34. As the petitioner is unwell, my lord, kindly post it to day after a week, my lord.
Please do finally as a last chance. Adella hakkondu.
And
Yes.
interim order kindly be extended.
Lords, 36 and 38, my lords, for the petitioner. Kindly have it, my lords, tomorrow. Some inconvenience today, my lords.
36 and
38, my lords. Both I will.
why not today? Why tomorrow?
Lords, my senior, my lords, wants to argue these matters. Division bench ಅಲ್ಲಿ ತುಂಬಾ ಇದೆ ಸ್ವಾಮಿ ಇವತ್ತು. Kindly have it tomorrow, my lords.
ಅದು ಲಿಸ್ಟ್ ಆದಾಗ ಒಂದು ನಿಮ್ಗೆ ಟೈಮ್ ಇರಲ್ಲ, ಬೇರೆ ಟೈಮೇ ಬೇಕು. 36, 38 praise for time. System.
Happy to. Lords, interim order may be extended. Great.
Next.
This one, serial
What
number
about 37?
37, my lords, I will withdraw it, my lords. I will file my memo. Case has been withdrawn before the trial court.
sheet.
You are filing a memo
I'll give it.
as
Maybe,
not pressed?
yes, my lord. With the liberty, my lords, if at all they prefer. This is 138 proceedings. They have settled the matter before the Lok Adalat, my lords, on 13th of.
Settle ಆದ್ಮೇಲೆ ಮತ್ತೇನಿದೆ? Prefer
If
in
at all,
appeal,
my
where
lords.
is the question?
If they, my lords, I'll
Where
just.
is the question? Which law
Correct.
provides for that?
Lordships are right. I'll file the memo right away.
Not press.
Yes.
Counsel for the petitioner filed a memo seeking permission to not press the petition as the settled out of court. Memo is placed on record. Petition is dismissed as the same as.
Great.
Yes.
Next one, serial number 1, Uday Aras.
Lordship, appearing for petitioners.
ಅಲ್ಲ, ಇದು report in respect of petition number 1 and 2 ಅಂತ ಇದೆಯಲ್ಲ. Yes, what is your name? Who is
My proxy counsel, Lordship. The counsel on record is out of station, my Lordship.
No, you are representing whom, sir?
Petitioners, my Lordship.
Petitioners 1 and 2.
Yes, my Lordship.
Huh?
Yes, my Lordship.
Who is the advocate on record?
Desi Aras was earlier counsel, my Lordship. He is no more now. The another Uday Aras is on record now.
But he has not filed wakalat.
Lordship, in 2017 itself, he was on record.
No, where is the wakalat? Whether he has filed wakalat? No.
Yes, filed the wakalat, but
Where is
because
that?
of
No, time with senior.
signature ಮಾಡಿದ್ದಾರೆ Lordship.
ಇಲ್ಲ round up ಆಗಿದೆ.
ಅದು round up ಮಾಡಿದ್ದಾರೆ sir, because of officer.
round up ಆದ್ಮೇಲೆ ವಕಾಲತ್ ಅಂತ ಹೇಗೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ?
ಅದು
Why
office
it was rounded out?
ಒಂದು ಆಫೀಸ್ ಎರರ್ ಇಂದ ಆಗಿದೆ ಅನ್ಸುತ್ತೆ Lordship.
ಇಲ್ಲಿ ಹೆಸರಿಲ್ಲ, ಇಡೀ ವಕಾಲತ್ನಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರಿಲ್ಲ.
Because 2000
Look into that.
we'll file fresh wakalat Lordship. We'll file.
ಅದನ್ನ 2017 matter.
Yes.
Interim order is in operation.
Yes.
I will vacate that.
No,
Immediately
Lordship,
will file wakalat. No, I will today.
Please,
I
Your
will
Lordship.
vacate the wakalat.
Kindly extend the interim order.
Is nothing
I'll file today itself.
You are
Lordship.
enjoying the benefit of the interim order and leisurely you are saying there is wakalat.
No, Lordship, that was a mistake and I didn't.
Appreciate this conduct.
Kindly extend the interim order. We will file the wakalat today itself, Lordship.
Then at counsel Uday Aras submits that he represent the petitioners and that he will file wakalat before next date of hearing. The petition is of the year 2017. Till date, the counsel has not filed his wakalat. In spite of issuance of notice through police. Petitioner is enjoying the benefit of the interim order. Under these circumstances, I do not find any reason to adjourn the matter or to extend the interim. However, to afford final opportunity this time. ಇಲ್ಲ pass over ಮಾಡಿ ಅಂತ. You go through the 2024 order sheet. All these are already narrated. And in spite of that, there is no steps are taken. Pass over.
Much obliged.
Serial number 2, Nagbhushan Reddy.
My lordship, this petition has become infructuous, my lordship.
Why?
Charge sheet they have challenged the crime number, my lordship. The charge sheet was filed in the year 2022 itself, my lordship.
Now, what is the stage before the trial court?
It is showing appearance of the parties, and it since stay is operating, it is showing await orders, my lordship.
Interim order is there?
Please, my lordship. Interim was granted on 8/6/2022, my lordship.
Pass over. Huh? Yaru? Okay. Good. Counsel for the petitioner filed a memo seeking permission to retire from the case. It is stated that he is not getting any instructions from the petitioner. Next, the CGP submits that the charge sheet is already filed in the year 2022, which was never challenged by the petitioners, and therefore the petition is rendered infructuous. Next, in view of the above, the memo filed by the learned counsel for the petitioner is accepted. He is permitted to retire. Petitioner called out absent. Petition is dismissed as the same is rendered infructuous. Next.
Serial number 3, Nagbhushan Reddy.
What happened here? Final report is filed.
My lord, yesterday informed to the concerned police station, my lord, kindly pass for the matter, my lord. I will.
Counsel for the petitioner and filed a memo. Pass over me. Giri.
Serial number 4, B. Latif.
Yes, notice.
Close relatives serve ಆಗಿದೆ.
Notice issued to
64 is
respondent
come.
number 2 is served on his wife. Service is held sufficient. Respondent number 2 called out absent. Called out absent. Yavaga. This time.
Please. It's covered, my lord, because already other accused are acquitted.
Ready? Yeah, over. Who is the petitioner?
This is accused number 6, my lord.
Accused number 6.
ಹೌದು.
In all, how many accused were there?
13 accused.
What are the offense?
Offense, my lord, initially, my lord, 393 was invoked against unknown 2 person. Then, my lord, charge sheet was filed with an allegation of 307, 511, 34, read with 120B. That is an attempt. 307 was invoked, my lord, along with the 511. And with an allegation of conspiracy, this petitioner has been implicated.
How many accused? 13 accused.
13 accused. Accused number 2 to 5, 7, 8, and 9 are acquitted.
2 to 5?
7, 8, and 9. In the charge sheet, there is no specific allegation at all against this petition.
Why no trial was held against you?
No.
Why trial is not held against the petitioner?
I was not appeared before the court.
Absconding.
Absconding.
How can you take advantage of that? Face the trial.
Lord, the allegation, kindly see the
Put
charge.
the other accused. A1, 3, 5,
A1 and 10.
11. What about 1, 3, 4, 10, 11, and 6? 11
1,
and 13.
3, 4 are acquitted.
Huh?
A2 to 5, 7, 8, and 9 are acquitted.
2 to 5 acquitted. 7, 8, and 9 are acquitted.
Please.
What about 1, 10, 11, 12, and 13?
Please. Only 10.
Sir, accused number 1 to 13 ಅಂದ್ರಲ್ವಾ?
Sorry. 10, 10.
10.
10.
So what happened to accused number 1 and 10?
That status, they are split up ತೋರಿಸ್ತಾ ಇದೆ judgment ಅಲ್ಲಿ. Kindly see the charge sheet allegations, Lord. My role is not at all forthcoming in the charge sheet also. Page number 44 ಅಲ್ಲಿ. ನನ್ನ ಮೇಲೆ allegations ಏನು ಇಲ್ಲ.
Charge sheet was filed.
Sorry.
Charge sheet was filed in the year
2010.
After filing the charge sheet, you came before this court.
Sir.
Yes. Early the charge sheet.
44 ಅಲ್ಲಿ.
Charge sheet was filed in the year 2012, my lord.
2012.
ಹೌದು.
Date of offense?
Date of offense is on
2010. There is an interim order from this court.
That is the mistake we are committing.
And the allegation, kindly see the allegations. My role is not forthcoming in the charge sheet.
Date of offense.
2006, my lord. They have not mentioned the date in the charge sheet. It is mentioned.
2006 offense.
ಇಲ್ಲ 2010 FIR kindly see.
FIR ಎಲ್ಲಿದೆ?
2010.
Where is the FIR?
Complaint FIR at page number
25/2010.
ಹೌದು.
Date of acquittal of other accused?
That is blood on 27/10/21. Replacing two judgments of the apex court blood in similar circumstances. About the proclaimed offender also, when the allegations are one and the same.
First charge sheet ತೋರಿಸಿ.
Please.
Allegation ಏನಿದೆ?
Page number 44 ಅಲ್ಲಿ. Sorry. 3 number ಹಾಕಿದ್ದಾರೆ. ನಿಮ್ಮ ಹತ್ರ ಇಲ್ಲ. Typed copy complaint ಹಾಕಿದ್ದಾರೆ 3 number. A6 blood.
Read column number 17.
Please. 1ರಿಂದ 10ನೇ ಆರೋಪಿಗಳು ಕೆಎಫ್ಟಿ ಪಾಪ್ಯುಲರ್ ಫ್ರಂಟ್ ಆಫ್ ಇಂಡಿಯಾ ಸಂಘಟನೆ ಸಕ್ರಿಯ ಕಾರ್ಯಕರ್ತರಾಗಿದ್ದು ಆರೋಪಿ 5 ಮತ್ತು 6 2010ನೇ ಇಸವಿಯಲ್ಲಿ ಸುರತ್ಕಲ್ ಪೊಲೀಸ್ ಠಾಣೆ ವ್ಯಾಪ್ತಿ ಹೊಸಬೆಟ್ಟು ಎಂಬಲ್ಲಿ ಬಿಜೆಪಿ ಮುಖಂಡ ಸ್ವಯಂಸು ಹತ್ಯಾಪ್ರಕರಣ ಅಪರಾಧಿಯಾಗಿದ್ದು ಈ ಆರೋಪಿಗೆ ಕೆಎಫ್ಟಿ ವಕೀಲರಾದ ಮೊಹಮ್ಮದ್ ನೌಶಾದ್ ಕಾಸಿಂಜಿ ಎಂಬುವರು ವಕೀಲರಾಗಿದ್ದು ಸದರಿ ವಕೀಲರು 2009ನೇ ಇಸವಿಯಲ್ಲಿ ಮಂಗಳೂರು ಠಾಣಾ ವ್ಯಾಪ್ತಿಯ ಪಳ್ನೀರ್ ಬಿಟ್ಟು ಲೇನ್ ಎಂಬಲ್ಲಿ ಹಿಂದೂ ಸಂಘಟನೆ ಹತ್ಯೆಯಾಗಿದ್ದು ಈ ಹತ್ಯೆಗೆ ಸೇರಿಸಿಕೊಳ್ಳಲು ಸಂಘಟನೆ ಕಾರ್ಯಕರ್ತರು 1ರಿಂದ 10 ಗುರುಪುರದಲ್ಲಿ 2ನೇ ಆರೋಪಿಯಲ್ಲಿ ಸಭೆಯನ್ನು ಚರ್ಚಿಸಿ ಎಲ್ಲ ಆರೋಪಿಗಳು ತಮ್ಮ ಮೊಬೈಲ್ ಫೋನ್ಗಳು ಒಬ್ಬರಿಗೊಬ್ಬರು ಮಾತಾಡಿ ಹಿಂದೂ ಸಂಘಟನೆ ಸಕ್ರಿಯಕರ್ತರಾಗಿರುವ ಸ್ವಯಂಸವರನ್ನು ಹತ್ಯೆ ಮಾಡುವ ಸಂಚು ರೂಪಿಸಿದ್ದು ಈ ಹತ್ಯೆಯನ್ನು ನಡೆಸಲು ವಿದೇಶದಿಂದ 10ನೇ ಆರೋಪಿ ಸ್ವಯಂಸು ಒದಗಿಸಿತ್ತು. ಆರೋಪಿ 8ನವರು ಕೃತ್ಯಕ್ಕೆ ಮೋಟಾರ್ ಬೈಕನ್ನು ಒದಗಿಸಿದ್ದು 5 ಮತ್ತು 9ನೇ ರಿವಾಲ್ವರ್ 6 ಜೀವಂತ ಗುಂಡುಗಳನ್ನು ಸಾಗಿಸಿದ್ದು. ಮೊದಲಾಗಿ ವಕೀಲರಾದ ಈ ಪ್ರಕರಣದ 4ನೇಯವರಿಗೂ ಸಾಕ್ಷಿಗಳನ್ನು ಹತ್ಯೆ ಮಾಡಲು ನಿರ್ಣಯಿಸಿ ಚರಣವರನವರಿಗೆ ಆರೋಪಿಯವರಿಗೆ 7ನೇವರೆಗೆ ಮಾಹಿತಿ ನೀಡಿದಂತೆ 1, 2, 3, 4ನೇ ಆರೋಪಿಗಳು 4 ಮೂಡಬಿದ್ರೆಗೆ ಹೋಗಿ ಸಾಕ್ಷಿ 4ರವರು ಮಧ್ಯಾಹ್ನ ಊಟಕ್ಕೆ ಹೋಗುವಾಗ ಮನೆಗೆ ಹೋಗುವ ರಸ್ತೆಯಲ್ಲಿ ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶಿಸಿ 3, 4, 7ರವರು ಸಾಕ್ಷಿನವರ ಕಚೇರಿಯನ್ನು ಹೋಗುವುದನ್ನು 1 ಮತ್ತು 2ರವರಿಗೆ ಮಾಹಿತಿ ನೀಡಿ 1 ಮತ್ತು 2ರವರು ನ್ಯಾಯಾಲಯದ ಮೂಲೆಯಲ್ಲಿ ಬಾಂದ್ ಎಂಬಲ್ಲಿ ರಸ್ತೆಯಲ್ಲಿ ಕಪ್ಪು ಬಣ್ಣದ ಪಲ್ಸರ್ ಮೋಟಾರ್ ಬೈಕ್ ಅನ್ನು ಚಾಲು ಸ್ಥಿತಿಯಲ್ಲಿ ಇಟ್ಟಿರುವಾಗ ಮಧ್ಯಾಹ್ನ ಸುಮಾರು 1 4ನೇ ಆರೋಪಿ ಮತ್ತು ಸಾಕ್ಷಿ 1ರವರು ಬರುತ್ತಿದ್ದನ್ನು ಕಂಡು ಒಮ್ಮೆಲೆ ಮೋಟಾರ್ ಬೈಕ್ ಅನ್ನು ಚಲಾಯಿಸಿ ಹೋಗಿ ಡಿಕ್ಕಿ ಹೊಡೆದು ಇಬ್ಬರು ಬೈಕ್ ಸಮೇತ ರಸ್ತೆಗೆ ಬಿದ್ದು ಆಗ ಸಾಕ್ಷಿ 1ರವರು ಕಾರು ಕೆಳಗೆ ಇಳಿದಾಗ ಬೈಕ್ ಸವಾರರು ರಸ್ತೆಯಲ್ಲಿ ಬಿದ್ದುಕೊಂಡು ಕೂಗಿತ್ತು. ಆಗ 2ನೇ ಆರೋಪಿ ಕಾರಿಗೆ ನೋಡುತ್ತಾ ಬೆನ್ನಲ್ಲಿದ್ದ ಬ್ಯಾಗಿಂದ ಹತ್ತಿ ತೆಗೆದು 4ನೇ ಆರೋಪಿಗೆ ಯತ್ನಿಸಿರುವುದು ಮೂಡಬಿದ್ದು ಸ್ವಯಂಸು. Single evidence is not there about A6.
Yes, what is it?
Even though there is no specific allegation against A6, there is a conspiracy.
Who speaks about general? That is accused number 1 to 10. 1 to 10 anta. There is an allegation against accused numbers 1 to 4 who are at the spot. Accused number 8 has provided the motorcycle. Accused number 5 and 9 have provided a revolver with live bullets. No such allegation against this petitioner.
Parent, the judgment is clear. Para number 27. Page number 63.
Sorry. Internal paragraph 27 of the judgment. Hence, the charges leveled against Second 2 and 7, so accused number 8 has been established in prosecution. Ownership of the bike so has not been established prosecution. PW 1-2 had failed to identify the accused, since both of them are not corroborating with regard to those persons who are wearing the helmet. Thereby, the identity of the accused is trial highly improbable. Moreover, there is no recovery from the accused 1 and 2. Though the charges against accused number he assisted the other accused providing motorbike. The same is not at all established with the prosecution. In the same manner, providing revolver or live cartridge to the accused number 5 and accused number high not at all been established, other than drawing the muzzle at the place where alleged the transaction for providing revolver was conducted. There is no absolute, no cogent evidence to connect the accused number 5 to 9 with the conspiracy and any other by other accused by providing revolver or live cartridge. And there is also no proof that accused number 7 had given information about the movements of PW3 to the Prasad Evide. Though PW5 D'Souza had filed spoken about the stranger had come to the place and inquired about PW3, there is absolutely no prosecution to show that PW3 had indeed seen the picture of A7 in the newspaper. In fact, A123 come to two-wheeler on a so and so is not proved by the prosecution.
Yes, third. Petitioner being accused number 6. In CC 284 of 2007. CC 284 is already disposed of.
Here, 247, 284/17.
It is pending.
Yes.
284 of 2017. Pending on the file of the learned civil judge and JMFC Padbidra, arising out of crime number 70 of 2010 of Mudbidra Police Station, registered for the offence punishable under section 120B, 307, 511, read with 30, section 34 of IPC, is seeking to quash the criminal proceedings initiated against him. Third submission. There is limited point of consideration may answer to the point in the affirmative for the following reasons. Initially, he has not sustained any injuries. No injuries. PW1. CW. Oh, yeah, CW2 ಆಗೋದೆ. ಚಾರ್ಜ್ ಶೀಟ್ ನಲ್ಲಿ ಯಾರು ಅಲ್ಲ CW ಎಷ್ಟು CW1 logged the first information with the Murgidar police on 2/5/2010 alleging that on the previous day some unknown persons have made an attempt on his life and therefore the case under section 393 only 393 FIR 393 of IPC was came to be registered against unknown two persons. Investigation was undertaken and the charge sheet came to be filed during 2012 against accused numbers 1 to 10 for the offence under section 120B, 307, 511, read with 34 of IPC. The petitioner being accused number 6 is before this court seeking to quash the criminal proceedings. Next, as per column number 17 of the charge sheet filed by the investigating officer, accused number 1 to 4 were at the scene of occurrence and they actively participated in commission of the offence. Accused number 5 and 9 have provided the revolver with 6 live bullets, while accused number 8 has provided a motorcycle. An omnibus allegation is made that accused number 1 to 10 have conspired together to cause the death of CW1 and they were having a motive. But there is no specific allegation regarding commission of any overt act by the present petition. Next part. It is brought to the notice of the court that the trial against accused number 2 to 5, 7, 8 and 9 is already held before the trial court and they were acquitted. The trial court made an observation at para number 27 of its judgment that PWs 1 and 3 have not identified the assailants There was no recovery at the instance of the accused who were tried before the trial court. And the charge against accused number 2 to 5, 7, 8, and 9 are not proved by the prosecution. Even though there are specific allegations against these accused who were tried before the trial court, there were no materials to constitute the offense and to convict them. But regarding but the charge sheet discloses that there is no specific overt act alleged against the present petitioner, except saying that he is part of conspiracy with the co-accused. Under such circumstances, conducting trial against the petitioner, nothing but a futile exercise. Under these circumstances, the continuation of criminal proceedings is an abuse of process of law. In view of the above, I am of the opinion that the criminal proceedings against the petitioner is liable to be quashed accordingly. So it's affirmative quashed. Admission. Yes, hello.
Serial number 5, Sanket. Sanket.
ಯಾರಿದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಯಾರು ಹಾಕಿದ್ರು ಯಾರು ಹೆಸರೇ ಬಂದಿಲ್ಲ ಏನು ಅಬ್ಜೆಕ್ಷನ್ಸ್ Counsel for the petitioner is absent. However, name of the advocate for respondent number 2 is not shown in the cause list. Respondent number 2 is directed to comply with the office objections raised on the statement of objections by serving the copy on the learned counsel for the petition and SG for respondent number 1. This term. Next.
Serial number 6.
Are you directed to show his name in the cause list?
Monica Patil, DC owner.
Objections. What is the objection? Preamble portion of the order sheet. That is the certified copy. Heard learned counsel for the petitioner on office objection at serial number 2. It is stated that the petitioner has produced the certified copy of the order sheet in crime number 73 of 2018, but the preamble portion is not furnished. Thus, the submission is accepted. Office objection at serial number 2 is ignored. Yes. Office objection is ignored. 22 matter. What is the stage before the trial court?
My lord, investigation was
When will you? No further date will be given. Counsel for the petitioner pays for time. The petition is of the year 2022. Learned HCGP and learned counsel for respondent number 2 opposes granting of time on the ground that the petitioner is enjoying the benefit of the interim order and therefore the investigation could not be carried on. Counsel for petitioner undertakes to address arguments on the next date of hearing without fail. Submission is placed on record, list on in 4 weeks.
Serial number 7. GM Srinivas Reddy.
Interim order will be extended.
Appearing for respondent number 2, my lord. I'll comply, my lord. Kindly a date may be fixed, my lord.
Why you are not furnishing the copy to the other side?
I'll furnish, my lord. There kindly a date may be fixed. I'll do it, my lord.
Come and serve the copy on the other side.
Much
Why it
obliged,
is
my lord.
taking-
I'll do it, my lord.
Huh? First, she has to serve the copy also. Counsel for the petitioner undertakes to serve the copy of the copy.
And for the respondent number 2, my lord.
Counsel for the respondent number 2 undertakes to serve the copies of the statement of objections, memo of citation, and IA 1 of 2025 on the learned counsel for the petitioner during the course of the day.
Much obliged, my lord.
Next. Interim order extended. Next.
Serial number 8, second project.
Counsel for the petitioner is absent, no representation, notice issued to respondent number 2, returned unsserved. Right now, they are.
Charge already framed, my lord, in this matter.
Yeah.
Charge already framed on 22/9/2023.
Learned HCVT submits that the
And the
charge
issue
is
SS to CW12.
Yavaga?
22/9/2023.
23.
And issue is summons to the CW 123.
Summons is already issued to CWs 1 to 3. List down. Hold on,
Serial number 9, Rukojira Kumari M.
ಯಾರಿಗೆ R2ಗೆ you are for ಏನು yes don't bother about the other side. You are representing the petitioner. Complaints of office objection raised on IA2 memo of retirement filed by respondent number 2 anybody. Learned counsel for respondent number 2 filed a memo seeking permission to retire from the case as the entire case papers with no objection. Wakalat is already taken by respondent number 2. Memo is placed on report. Memo. The memo is signed by respondent number 2 for having received the entire case papers for the purpose of engaging the services of the advocate. Hence, memo is placed on record and the counsel so and so is permitted to retire from the case. Respondent number 2 called it absent, remained absent. Yes, when will you argue? Counsel for the petitioner prays for time to address the argument on marriage. List down. Next.
Serial number 10, Mahadev Arke, A. Sampath, Harsha D. Joshi, Shanti Joshi.
It's done, my lord. I filed an amended petition morning, my lord.
Non-filing of amended cost title.
I filed it morning.
Submits that he has filed the amended cost title in the registry. Office to verify. Amend ಮಾಡಿದಾರಾ? Yes. When will you argue?
It's next Tuesday. I'll argue.
Counsel for the petitioner prays for time to address arguments on marriage. List down. Next.
Interim order. Obliged.
Number 11, Vijay Krishna
For the petitioner. For the petitioner.
Copies of
Line. Getting a year at this, 25 back.
Who filed? You filed IA 1 of 25? Then from where these applications came?
One is filed for vacating this step by the state.
By HCGP.
In the year of 2023.
Yes. Who filed this IA 1 of 25? Government filed ಮಾಡಿ. Regarding maintainability.
But here also not.
Why maintainability
not
is raised?
But IA not filed.
Objection regarding maintainability of IA.
Which IA?
Second IA, I think the office has raised objection on the second IA. How the second IA is maintainable
Second IA is also for vacating.
by the state.
When will you argue the matter?
Next Monday.
Finally.
Yes.
Other matter, last mechanism, the other matter, 78, 99 of 24 has been, the connected matter has been.
Connected ಎಲ್ಲಿದೆ ಅದು ಇಲ್ಲಲ್ಲ.
The earlier matter has been ordered by the Sun before in 78, 99 of 24. The court allowed this matter to be back to both the cases.
New matter.
Is notice that
New
the
matter.
state represented by learned HCP
new
filed
matter.
IA 1 of 2023 and again IA 2 1 of 25 seeking vacating of the interim order. Next, learned counsel for the petitioner and respondent number 2 and 3 undertake to address their arguments on merits on the next date of hearing without fail. Commission is placed on record IA number 1 of 25 and disposed of, directing the parties to address their arguments on merits on the next date of hearing without fail. Next, learned counsel for respondent number 2 and 3 submits that
7899 of 24.
criminal petition number
784499 of 24
is connected with the present petition, hence may be listed along with the present petition. Office is directed to verify the same and list both these cases together. Yes.
No, interim order may be extended.
But you have to address the arguments
Yes.
on the next date of hearing.
Yes.
No further reason.
Yes.
Serial number 12, George Joseph, Rohit Vijay.
No, interim order may be extended.
Yes, yes.
Yes.
Appearing for the petitioners, my lord. My lords, in this matter, we are led by senior counsel Mr. KG Raghavan. He's out of the country at the moment, my lords. May I request for the matter to be had after about 10-12 days, my lords. He's returning the last week of.
Counsel for the petitioner, please for time.
I represent respondent number 6, my lord.
Yes. Counsel for the petitioner, praise for time. There is application for vacating stay.
Moved by the state, my lords.
Please.
Why it should not be allowed?
My lords, this,
Well, vacate the stay, thereafter legend it by another 1 or 2 months.
My lords, the interim order was granted after hearing both the sides. My lord, the state has moved the application after 5 years.
Since you are not ready to address the arguments on merits, there is no point in extending the interim order.
My lords, in fact, on every earlier occasion, we have commenced arguments. It was the HCGP who had requested. Yes.
I don't know.
Yes, my
Not
lords.
there.
In fact, the order sheet also in December record, Mr. Raghavan had commenced arguments also in the matter. And then since the HCGP had not accepted notice, notice was reordered in 4th of.
HCGP has not accepted.
Because
What is the reason?
On 4th of December, my lords, it was reissued. We had in fact commenced arguments.
What do you order sheet? December.
The concerned officer,
Order sheet reads, at the request of learned counsel for both parties, this matter on 6-1. There is nothing to state Mr. Raghavan has addressed, ready to address the argument. He has addressed. CGP was not ready. No such. From where you got that?
I apologize, my lords. I may have mentioned the wrong date. I apologize. It happened in December, my lord. Any date may be fixed, my lords. I will request Mr. Raghavan to appear on
Make a
VC.
submission before the court. You should be very certain about that.
I apologize, my lords.
There is nothing in this order sheet.
Notice was ordered, my lord. I'm
At the request of both the learned counsel, list on.
I apologize, my lords.
Counsel for the petitioner, praise for time. She undertakes.
My lords, sorry, my lords, on 11/11/2025. Apologize, my lords. Yes, my lords.
Yes, what is there in 11-11?
My lords, I was only trying to say we have not taken time prior to this. Any date may be fixed, my lords. We will appear, Mr. Raghavan will appear on VC, my lords. May I only request that it may be had after 2 weeks, my lords. He'll have to make arrangements.
When there is nothing to suggest that the counsel for the petitioner was ready. Nothing is there.
It doesn't, yes, my lords.
Mr. Jagdish accepts notice, HCGP accepts notice, registry to show the name of their names in the cause list. Delete the name of so and so, show the name of so and so. That's all.
I apologize, my lords. What had transpired was
Number 13.
well, its interim order may be extended.
The council undertakes to address the arguments on the next date of hearing. Subject to the condition, the interim order is extended for weeks. Yes, next.
13th PN Nandha Reddy.
Who is for respondent number 2? Yes.
In this case, by inadvertence, the sale deed was, the petitioner is the owner of the properties. Giant development was given.
Who is the petitioner?
Petitioner is the owner of the.
Yes, sir. Or accused irbekalva.
Accused only, sole accused.
Sole accused. Aste. Offense, what is the offense?
420 millard 511. That the flat, in this case, the flat has, the apartment has been sold in favor of the complainant.
Accused sold.
Accused. On 36/2016.
Yes.
By inadvertence, on 13/11/2018, in respect of the very same apartment, sold to one Patel Ventures.
Inadvertence.
ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಜಾಸ್ತಿ ಅಪಾರ್ಟ್ಮೆಂಟ್ಸ್ ಇರುವಾಗ ಸ್ಟಾಫ್ ಕೊಡುವಾಗ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ.
ಆಯ್ತು, when it was brought to your notice, you could have settled that.
ಆಮೇಲೆ ಸೆಟರೇಟ್ ಮಾಡಿದೀವಿ ನೆಕ್ಸ್ಟ್. ದೇರ್ ಆಫ್ಟರ್ on 4/11/2019
on 13/11/2018 it was sold to
Patel Ventures.
Then
Millard on 2/11/19 complaint was given against accused. Millard on 4/11/2019 itself, sale deed was cancelled, executed in favor of Patel Ventures. It was rectified. And also later, when the complainant insisted for execution of confirmation deed from the Patel Ventures, that also has been executed on 14/11/2019.
Then
so now the complaint may not survive because I'm told that it appears that they have also informed the police to withdraw the complaint. I don't know what is the instructions they have.
Yes, what do you say?
My lord, as per the annexure produced by annexure D, confirmation deed is there, my lord. Before that, the 2/11/2019 the complaint is lodged.
I think immediately thereafter he has cancelled the subsequent sale.
But not only that allegation, there is a allegation, my lord, the biga murdu baga chilka biga murdu illegally
has been rectified. I have stated in my petition. Interiors, everything has been got it done. There is no.
Investigation was not undertaken.
Yeah.
Interim order was there.
The interim order.
Interim in operation.
So therefore,
the R2 is not interested. He has not appeared.
Yes.
I will record his submission and close it. ಮಾಡಿದಾರ?
ಮಾಡಿದ್ದಾರೆ ಸರ್.
ಎಲ್ಲಿದೆ ಇದು ಕ್ಯಾನ್ಸಲೇಷನ್ ಡೀಡು?
Annexure B,
ಪೇಜ್ ನಂಬರ್
page 48.
64.
Page 48. Deed of cancellation executed by the accused along with the Patel Ventures. But confirmation deed also executed.
ಇವರಿಗೆ ಎಲ್ಲ ನೀವು ಈ ರೀತಿ ಮಾಡಿದ್ರೆ ಏನ್ ಹೇಳ್ಬೇಕು?
Allah, of course, by mistake. That's a mistake. I'm not saying in. That's true, Millet. I actually initially I not implemented. This one court insisted Millet to implement.
Correct.
I'm sorry. Confirmation deed Millet page 64.
Now the possession is handed over.
Yes, they are in possession, and where they come, they have replaced all fittings and interiors also got it done. I have stated Melody.
ಏನು ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಂಡು ಮಾಡೋಣ. 2:30.
2:30.
2:30 and
Tomorrow. will also be.
230 ಮುಗಿಸ್ಬಿಡೋಣ.
ಆಗ್ಬೋದು. ಆಯ್ತು. Very well.
ಇಡಿ.
Serial number 14, the complainant
Petition.
M.R.
Majority.
ಇದು ಈ ಫೈಲ್ ಆಕ್ಚುಲಿ ಒಳಗೆ.
Let the petitioners who are the accused in a private complaint filed under section 200.
Accused number?
Accused number, well, these are all accused number 1, 2.
5.
Yes.
There are only 5 accused?
Yes, ma'am.
What are the
There are-
offense alleged?
Yes, ma'am. 5 accused, ma'am.
Offense?
191, 192, 193 of the 191, 192, 196, 120 A of the IPC. The learned magistrate,
Who is for the respondent?
respondent, sir.
Yari,
The learned magistrate, Mr. Narayan is present, my lord. He's there. Yes.
Okay.
Blood, the genesis of this litigation, my lord, the second petitioner is the owner of the property in question. He has entered into an agreement of lease with the first petitioner on 1/4/2015. My lord, annexure D is the agreement. It is at page 62, my lord. Page 62. Well, this is M. Babanna, son of Muni Venkatappa, between PM Granites Export Private Limited, so and so. Whereas the lessor is the owner of the residential property number so and so, so and so. Well, this is, the rental is 50,000 rupees. Well, this second petitioner gives this property to the first petitioner on lease so that it is utilized by the employees of the first petitioner company. Well, the rentals are paid and tax is deducted at source. Annexure E is the TDS certificate for number 16A, which your lordship may kindly come to page 67.
So what is the allegation?
Well, allegation is that this agreement which is entered into between the petitioner is a fabricated document produced before the court for the purpose of seeking an order of conviction under section 452 of the Companies Act, my lord. Now, he was an employee of the petitioner, first petitioner company. And in the capacity as an employee of the general manager of the company, that particular property was recognized as their official quarters in favor of the complainant. But the second respondent complainant.
Respondent number 2 was your employee.
Employee.
General manager.
Yes, general manager.
He purchased the residential premises.
Well, he has not purchased residence. He was given this particular premises in the capacity as an employee of the company.
Given Andre as
Given to reside as an official quarters for him to reside.
okay.
Yes.
So the premises belongs to company.
Premises is a lease property of the company.
Who is the owner?
Owned by the second petitioner.
Second petition.
Second petitioner is the owner of the property. Well, he resigned from the services of the company on 8/10/2016. His resignation was accepted.
Who resigned? R2 resigned.
R2 resigned. And on 8/10/2016, which are undisputed facts. Then he was called upon to vacate this premises as it requires to be given to some other employees who is going to take over. But after giving notices, others, a complaint was filed under section 200 PCR 13 of 2017 for the offences punishable under section 452 of the Companies Act. Section 452 of the Companies Act provides if an employee withholds the property of the companies, including the lease property of the company, it is an offence punishable. Magistrate court has a power to pass an order directing eviction of the property. It is a quasi-criminal proceeding.
Who filed PCR?
The PCR, first petitioner filed PCR. Well, at annexure R, page 161 is a PCR.
PCR number?
PCR number 13 of 2017. And it became annexure R, page 161 million. But in that complaint, these documents were produced to show that is the lease property of the company. The said complaint was dismissed on 18/3/2019 in CC number 236 of 2017. Annexure T is the order of the Learned Special Court for Economic Offences.
Dismissed andre ಮತ್ತೆ?
Dismissed on the ground that the property, the petitioners failed to establish the offence under section 452 of the Companies Act.
Dismissed on 18/3.
18/3/2019.
As the complainant has not proved.
Not proved the offence under section 452 of the Companies Act. Against that, a criminal appeal came to be filed before this court. This court, in criminal appeal number 827 of 2019, annexure we allowed the criminal appeal, stating that the special judge has not looked into the vital aspect of the matter and set aside the order of acquittal and remanded back the matter to the learned special judge. Annexure V, page 241 is the order of this court.
Annexure?
Thereafter,
Annexure?
Annexure V, V for victory, page 241. After this remand, I'll only read the operative portion of the order, which is at page, because that may not have much significance to decide that matter. It is at page 266. Para 18. In the light of in that light, appeal is allowed. Judgment passed by the Special Court for Economic Offences in CC number 236 of 2017, dated 18/3/2000. He set aside. The matter is remitted to the court below to dispose of the same in accordance with law. After there was no complaint filed by him. That one of the ground raised by him before the court was the stamp paper of the document, which is a lease deed, is purchased in Hosur, which is subsequent to the date of the lease agreement, is the defense which was taken. Now then, after the remand, the second respondent files a complaint to the police, Halsur Gate Police Station, where no cause of action has arisen, nothing has happened, on 16/1/2020. The complaint is at page 290. 290.
Yes.
Complaint, your lordship kindly say, complaint against the following persons for committing the offences under 128A. 128A is not a punishable offence. Yes, 120 capital A, section 192, 191, 192 and 196 of the IPC. Then he also files a complaint to the Commissioner of Police. This complaint, since the matter pertains to production of a document before the court, and therefore whether complaint can be entertained or not, the complaint is referred to the, I would like to draw the attention of the court, the averments in the complaint, which has the para 8 is the averments in the complaint. There is no allegation by the second petitioner alleging that this is a fabricated document. Both the parties and lessor and lessee admitted there is an agreement of lease in respect of the property. He is only a retired employee, resigned employee. His allegation is para 8, page 294.
Allegation with regard to the
With
lease
regard to
deed
those two documents, that is lease deed,
entered into
between the first petitioner and the second petitioner, creating a lease of this property in favor of the first petitioner.
no document was executed in favor of respondent number 2.
No document is executed in favor of him. He has been.
Respondent number 1 is the monorail. Respondent number 2 is the other.
I'm sorry, just one.
Therefore, it is case.
Yes, respondent.
Respond number, yes, 1. No document is executed in favor. He was allowed to enjoy that property.
Allegation is with regard to lease deed between petition number 1 and 2.
1 and 2. Petition number 2 is the owner of the property. Petition number 1, is the lessee of the company. I would like to draw the attention of the court, para 11, page 296,
He is still in possession.
He is still in occupation. In a suit, there was a direction to hand over the possession, and this court set aside, and then the matter is pending before the Supreme Court. There are multiple cases. I would like to only concentrate to the case which is relevant. Paragraph 11 is the allegation. Page 296. And 10 also I will read. 295, 11, 12, 13. Yes. It is submitted that the production of exhibit P3 and P42, they are one and the same. Honorable Court for Special Economics at Bangalore would not have entertained and registered the aforesaid complaint. Furthermore, the Honorable Court would not have remitted back the matter for trial court. Thus, the accused number 2 in the capacity as a managing director accused number 1, and while prosecuting the complaint on behalf of the accused, number 1 committed the offences under section 191 and 192 of the IPC. It is submitted that the accused number 2 has produced exhibit P42, another lease deed relating to the house property. This house is owned by the said accused number 2. Accused has taken the lease of the property, referred to the lease deed from the said accused number 2, and again permitted the accused number 2 to reside there as a rent-free quarters. This lease deed has also been fabricated, produced only to match the TDS made by the accused number 1 in respect of some other transactions. I have form number 26A, which I have worked with accused number 1 and 2 months, so and so. Then I will skip, kindly come to paragraph 12. That's what I said, that the accused number 3 and 4 are the directors and son of the accused number. Accused number 1 is a family concern. Therefore, they actively participated, helped, conspired accused number 2 in committing the offense. The substance of the complaint is, that this document is produced solely to file a complaint under section 452 before the special judge court is the allegation, before the court. This was referred to the special public prosecutor. The special public prosecutor has submitted the report, and the annexure AA, page 300. The public prosecutor was consulted, the inspector of police Halsur Gate has submitted the report on 3/10/2020. The substance is, it considers all. Kindly come to page 304. 304. ಸಂಬಂಧ ದೂರು ದಾಖಲಿಸಿದ್ದು ತನಿಖೆ ಪೂರೈಸಿದ ತನಿಖಾಧಿಕಾರಿ ಮೇಲ್ಕಂಡ ದೂರರ್ಜಿದಾರರ ವಿರುದ್ಧ ದೋಷಾರೋಪಣಾ ಪತ್ರವನ್ನು ಭಾರತ 408, 400, 420 ಅಡಿಯಲ್ಲಿ ಮಾನ್ಯ ನ್ಯಾಯಕ್ಕೆ ಸಲ್ಲಿಸಿಕೊಂಡ ಸದರಿ ಪ್ರಕರಣ ಸಿಸಿ ನಂಬರ್ 708 ದಾಖಲಾಗಿ ವಿಚಾರಣಾ ಹಂತದಲ್ಲಿ ಕಂಡುಬರುತ್ತದೆ. ಅದರಂತೆ ದೂರ ಅರ್ಜಿದಾರರು ಮತ್ತು ಪ್ರಕರಣ ಎರಡನೇ ಅಪ್ಪಿದ ನಡುವೆ ವೈಷಮ್ಯವಿರುವ ಕಾರಣ ಮೇಲ್ಕಂಡ ದೂರರ್ಜಿದಾರರು ತನಗೆ ಸಂಬಂಧವಿಲ್ಲದ ದಾಖಲೆಗಳನ್ನು ಪಡೆದು ಅನವಶ್ಯಕವಾಗಿ ಕಿರುಕುಳ ನೀಡುವ ದುರುದ್ದೇಶದಿಂದ ಹೊಂದಿ ಸುಳ್ಳು ಸಂಗತಿಯನ್ನು ಸೃಷ್ಟಿಸಿಕೊಂಡು ಈ ದೂರು ನೀಡಿರುವುದಾಗಿ ವಿಚಾರಣಾ ಕಾಲದಲ್ಲಿ ತಿಳಿದು ಬಂದಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸದರಿ ದೂರು ಅರ್ಜಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಾಖಲೆಗಳನ್ನು ಸಂಗ್ರಹಿಸಿರುವ ದಾಖಲೆಗಳನ್ನು ಮಾನ್ಯ ಅಭಿಯೋಜಕರು ಕಾನೂನು ಅಧಿಕಾರಿ ಕಿರಿಯ ಅವರ ಅಭಿಪ್ರಾಯವನ್ನು ಪರಿಶೀಲಿಸಿದ ನಂತರ ತಿಳಿದು ಬಂದ ಅಂಶವೇನೆಂದರೆ, ದೂರರ್ಜಿದಾರರು ಆಪಾದಿತರ ವಿರುದ್ಧ ಮಾಡಿದ ಆಪಾದನೆಗಳು ಸಂಬಂಧಪಟ್ಟಂತೆ ಈ ಹಂತದಲ್ಲಿ ಪ್ರಥಮ ವರದಿ ದಾಖಲಿಸುವುದು ಕಾನೂನು ಬಾಹಿರವ ಕ್ರಮವಾಗಿರುವುದರಿಂದ ಸದರಿ ವಿಚಾರದಲ್ಲಿ ಈಗಾಗಲೇ ಮಾನ್ಯ ವಿಚಾರ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ವಿಚಾರಣೆ ನಡೆದಿರುವುದರಿಂದ ಸದರಿ ದೂರು ಅರ್ಜಿಯನ್ನು ಮುಕ್ತಾಯಗೊಳ್ಳಬೇಕೆಂದು ಕೋರಿರುತ್ತದೆ. ಈ ವರದಿಯ ಜೊತೆ ಕಾನೂನು ಅಭಿಯೋಜಕರ ಅಭಿಪ್ರಾಯ ವರದಿ ಅರ್ಜಿದಾರರಿಗೆ ನೀಡಿರುವ ಹಿಂಬರಹ ಪ್ರತಿ ದೂರು ದಾಖಲೆಗಳನ್ನು ಹಾಗೂ so and so that's it. The public prosecutor has opined in case there is a bar to take the cognizance of the complaint itself, because complaint will have to be filed before the learned magistrate in that court which has received that document as an evidence, and therefore the complaint cannot be entertained by relying on section 195 read with section 340 of the, that is a view taken. Now this, he was given endorsement annexure AB page 305. AB, your lordships have that. I'll read last para only. ನಿಮ್ಮ ದೂರು ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿದ್ದು ನಿಮ್ಮಿಂದ ಎದುರಾಳಿಗಳಿಂದ ದಾಖಲೆಗಳನ್ನು ಸ್ವೀಕರಿಸಿ ಪರಿಶೀಲನೆ ಮಾಡಿ ನಂತರ ಕಾನೂನು ಅಧಿಕಾರಿ ಅಭಿಯೋಜನೆ ಇಲಾಖೆಯವರಿಂದ ಅಭಿಪ್ರಾಯ ವರದಿ ಪಡೆದಿದ್ದು, ಸದರಿ ಅಭಿಪ್ರಾಯ ವರದಿಯಂತೆ ನೀವು ಈಗಾಗಲೇ ದಾವೆ ಹೂಡಿರುವ ಮಾನ್ಯ ನ್ಯಾಯಾಧೀಶರು ವಿಶೇಷ ಆರ್ಥಿಕ ಅಪರಾಧ ನ್ಯಾಯ ಬೆಂಗಳೂರು ಇವರ ಎದುರಾಳಿ ವಿರುದ್ಧ ನೀವು ಮಾಡಿರುವ ಆಪಾದನೆಗಳು ಸಂಬಂಧಿಸಿದಂತೆ ಮುಂದಿನ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ವಿವೇಚನೆಗೆ ಒಳಪಟ್ಟಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ನಿಮ್ಮ ದೂರು ವಿಚಾರಣೆಯನ್ನು ಮುಕ್ತಾಯ ಮಾಡಿ ಹಿರಿಯ ಅಧಿಕಾರಿಗಳಿಗೆ ವರದಿ ನಿವೇಶಿಸಿಕೊಂಡಿರುತ್ತೇವೆ. ಇದಕ್ಕೆ ನಿಮ್ಮ ಮಾಹಿತಿಗಾಗಿ the substance of this endorsement is that you have to go before the very same court where this document is produced. Now these documents, when the complaint he is pursuing one, simultaneously he files a complaint under section 200, which is at page annexure B, page 44. On 18/1/2020, when the complaint was being examined by the police, he files his complaint under section 200. Your lordships have page 44.
Yes.
Yes. I will only here the first respondent is a complainant. The first accused is a company. Second accused is a director of the said company. Third and fourth, they are the third respondent is the wife of the second respondent. She is only the director of the company. Then the fourth, the accused is his son. He is also director of the company. being bound by law to make a declaration upon the subject, makes a statement which is false, which he either knows or believes to be false, does not believe to be false, is said to give the false evidence. Well, that is the definition of giving false evidence. Then page 192 malad is the section which has been filed. Section 191 malad is not a punishing section, it only defines what is giving false evidence. Fabricating the false evidence. 192 malad, whoever causes any circumstances to exist, makes a false entry in the books or records, electronic records, makes a document or electronic records containing the false statement, intending such circumstances false entry, false statement may appear in evidence in a judicial proceedings, in a proceedings taken by law before the public servant as such, or before the arbitrator, that circumstances, false entry, a false statement so appearing in the evidence may cause any person who is proceeding is in the form of opinion the evidence, entertain erroneous opinion touching any point of material result, is fabricating the evidence. Malat, this is only Malat defines the what is the fabricating false evidence. Malat. And that is punishable under 193. It's not even found in the order. Malat. False evidence is 193. Malat. Then comes the order is Malat 196. Malat. Using the evidence.
190.
Yes, 196. Malat.
Yes.
Whoever corruptly uses, attempts to use a true or a genuine evidence as whichever evidence which he knows to be false, fabricated, shall be punished in the same manner as if he gave a fabricated evidence. Well, this is with regard to using an evidence to be a false evidence here. Well, it's section 191 and 192, 128A, they are only the definitions. There is absolutely no application of mine.
So there is no reference to 128.
Yes, 128A is
128.
It is not an official section. 128A, kindly see 128A.
128 illa sir alli 128.
Allah, 120 capital A he has made it.
120.
Yes, 120.
128 Allah.
Allah, 120. 120 capital A.
Repeatedly saying 128.
I'm sorry. 120, your lordship may kindly see, it only defines what is the criminal conspiracy to agreement to commit an offense. That is 120 capital A. Yes.
Yes.
Capital. Definition of criminal conspiracy. When two or more persons agree to do or cause to be done an illegal act, an act which is not illegal by illegal means, such an agreement is designated as a criminal conspiracy. Yes. Like the Supreme Court in Narayan Rao, it is an agreement, all of them, they come together and participate, that entering into an agreement amounts to criminal conspiracy. My respectful submission, this has to go for two reasons. Order of the land magistrate. Subsequently, this writ petition was filed on 14/12/2020. After 3 days of filing of the writ petition, the FIR is registered. That has been challenged before your lordships. First of all, the order of the land magistrate has to go for one reason, that there is no affidavit filed by the complainant before the learned magistrate, which is essential for purpose of entertaining the complaint. Those are all, none of them are this except 196. They're all definitions. There's absolutely no application of mine by the learned magistrate while referring this matter, Millard. Kindly see, Millard, the complaint. Complaint is, Millard, it's absolutely without any affidavit. Page 155 is the last page of the complaint, Millard.
1 minute. Yes, what is that?
Page 55 is the last page of the complaint. There is absolutely no affidavit as required by the Honorable Supreme Court of India and Priyanka Srivastava case. Without an affidavit, the Honorable Supreme Court, now our High Court also in the very same case only has held without the affidavit, entertaining a complaint and referring under 156(3) is without authority of law is the view taken by this court. In fact, the judgment copies I have given it. Already one set of judgments I have given, another. But this judgment is a bunch of judgments are already filed, on 28th of May 2021. This some of them are overlapping. This your lordship may kindly see, first judgment of the Honorable Supreme Court.
It is well settled, sir.
Please.
It is known. ಯಾವುದು relevant paragraph ಯಾವುದು ಹೇಳಿ?
In this case, paragraph para 28, para 28 and 29, 28, 29 and 33 paragraphs.
Yes.
Page 19.
28.
Yes, page para 28, 29 and 30.
Yes.
Just may I take your lordship?
That's better.
Next. This is affirmed by the Honorable Supreme Court in Babu Venkatesh case 2022 5 SCC page 89 in that. In this case, the para 23, 24, 25, and this honorable court, in the very same this thing, between the same parties, has taken the view, without affidavit, referring the complaint under 153 is without jurisdiction. That is page 22. 28 is the ratio. This court has in the between the same parties has laid down the accepted and quashed the criminal proceedings, page 22. So therefore, in fact, even 2025 series of judgments this court has held without an affidavit, entertaining a complaint and referring under 156(3) is without jurisdiction. My first respectful submission is that. My second respectful submission, the complaint, section 195 of the CRPC,
Section
195 of the CRPC, read with section 340.
Yes.
I'll just take your lordship's first section 340 of the CRPC. Yes. Provisions of offences. Your lordship's have?
Yes.
Yes. Provisions as to the offences affecting administration of justice. Procedure in case mentioned in section 195. When an application is made to in this behalf, otherwise any court is of the opinion expedient in the interest of justice, an enquiry should be made into any offence under in clause 3 of subsection 195 which appears to have been committed in relation to the proceeding in that court, as the case may be, in respect of document produced or given in evidence in the proceeding in that court, such court may, after making preliminary inquiry, if any, as is necessary, record a finding to that effect and make a complaint in writing, send it to the magistrate of first class having jurisdiction, take sufficient security for the appearance of the accused before the magistrate, or if the alleged offence is non-bailable, the court may think it necessary to send the accused to the custody of such magistrate, bind over the person. But this complaint requires me that now once an allegation is of production of a document in that particular court, the inquiry will have to be held by the very same court, and only that court has the power. No others has a power. A person who is an accused or a complainant has no jurisdiction to file a complaint before the magistrate. It has to be filed by the very same court after conducting the preliminary inquiry and finding that the said document is a fabricated document and there is a false evidence. Now here is a case where he goes and files a private complaint in respect of a matter which should have been an inquiry by the magistrate, where special judge who has conducted the trial. Now section 195 bars taking cognizance of those company. Kindly see page 195 195 the CRPC. When the court cannot take cognizance of the complaint, referring the complaint under 156(3) will be without jurisdiction. Kindly see 195. Prosecution, your lordship has.
Yes.
Prosecution for contempt of authority so and so against public servant for offences relating to documents given in evidence. No court shall take cognizance of offences. Your lordship may kindly skip. That is not this thing. The B. It's 1B. For the offences punishable and any one of the sections of the Indian Penal Code, section 193 to 196, 199, 200, 205 to 211 or 228, when such offence is alleged to have been committed in or relation to the court proceedings, then except on a complaint in writing of that court or by an officer of that court, as the court may authorize in writing in this behalf, or some other court in which the court is subordinate. So therefore, unless a complaint is filed by the court or officer of the court, the complaint for the offences under the section 193 to 196, now the offence as is made out is only 196. So there is a complete bar to take cognizance of the complaint itself. And unless that complaint is filed by the officer of the court and on behalf of the court, such complaint is required to be filed. Now the learned magistrate, he doesn't look into any one of these. There is series of lines of judgments of the Honorable Supreme Court, wherein courts have held that I'm sorry, when the complaint is filed, alleging, giving a false evidence, fabricating of the evidence, only that court has a power to inquire into, conduct a preliminary inquiry, file a complaint. Other than the court, no other individual has a power to file a complaint. Yes. Now, in fact, I have given the bunch of judgments on the your lordship kindly. On 28th of May 2021, I filed court of judgments. Judgments.
Judgments in 195 bar.
Yes, madam.
Yes, that is also settled position.
Settled position.
Yes.
It is only there are this thing the series of judgments where they have this thing. Now allegations now the kindly see the absolutely there is a learned magistrate he doesn't consider any one of them whether the complaint alleges makes out a case to refer it to the police under 153. And then secondly, more importantly, he has the here suppresses the complainant suppresses the report already submitted by the police stating that He has been advised, you go to the very same court which is where the document is produced.
Which is the citation you are relying on 195 bar?
There are 1992 3 SCC. There is another set of judgment I have produced.
No,
Even
no,
in
I'm
this also I
having-
have produced. Yes.
I am having that, which
Yes,
is the
Malad.
citation.
Yes,
You cite
Malad.
only one decision.
Yes,
Not,
I will. The first judgment, Malad, of the this Malad, Bandekar judgment. First judgment, Malad, I will. Ahalat, kindly see, Malad. This is page 69, Malad. MS Ahalat versus State of Haryana.
No, that is not there, sir.
Yeah, Your Lordship, the present judgment I gave it, Malad. In that only I have produced that also. There is overlapping. I am sorry, Malad.
Overlapping ಯಾಕಬೇಕು ಒಂದನ್ನು ಹೇಳ್ಬೇಕಷ್ಟೇ.
ಅಲ್ಲ ಅದು ಕಂಪೈಲೇಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಎರಡು ಕಾಮನ್ ಮಾಡಿ.
That is 2001 SEC.
Yes, Malad. 2000 volume 1 SEC 278, Malad, paragraph 5, Malad, and 6, Malad, of the judgment.
Paragraph number?
Paragraph number 5 and 6, Malad.
Yes.
Yes, is at page 72, Malad. Chapter 9 of the IPC deals with false evidence and offences against public justice 193 occurring therein provides for punishment for giving, fabricating false evidence in judicial proceeding. Section 195 of the Code of Criminal Procedure provides where an act amounts to offense of contempt of lawful authority of public servant or to an offense against public justice such as giving a false evidence under section 193 or to offense relating to the document actually used in the court, private prosecutions are barred absolutely. Only court in relation to which offense was committed may initiate the proceedings. The provisions of section 195 are mandatory. No court has a jurisdiction to take cognizance of any offense mentioned therein unless there is a complaint in required under the section. It is settled law that every incorrect and false statement does not make incumbent on the court to order prosecution, but exercise the judicial discretion to order prosecution only in larger interest of administrative justice. Section 340 of the CRPC prescribes the procedure as to how the complaint may be preferred by under section 195 CRPC. While under section 195 CRPC, it is open to the court before which the offense was committed to prefer a complaint for prosecution of the offender. Section 340 prescribes the procedure as to how the complaint may be preferred. The provisions under section 195 are mandatory. No court can take cognizance of offences therein. In respect of such offences, the court has a jurisdiction to proceed under section 340 of the CRPC. Complaint outside the provisions of CPC cannot be filed in any civil, revenue or criminal court under inherent jurisdiction. Malad, this has been, Malad, followed, Malad, in the another judgment, page 77, Malad, Perumal versus Janaki. Para 13 and 14, Malad, page 84, Malad. That in so far as the order of the learned magistrate, Malad, yes, sir.
Yes.
Order of the learned magistrate, Malad, no application of mine, Malad. Your lordships are aware there are series of judgments, Malad, where the starting from PepsiCo, Malad, the Supreme Court held, Malad, referring the matter, a complaint and initiation of criminal proceedings, Malad, is a very serious matter, and therefore there must be an application of mine, Malad. The learned magistrate simply says, Malad, I have perused the records, and he says you refer it to the under 156(3) for investigation without examining the averments in the complaint, where there is a clear averment that these documents are produced in the court for the purpose of getting him convicted under section 452 of the Companies Act. Well, then I have only one copy of 2018 where this court, my lord, has taken the view, my lord, when referring the complaint also there must be an application of mind. That's all, my lord. Therefore, this order will have to go, my lord. Subsequently, after filing the writ petition, my lord, one day before the interim order, my lord, the FIR is registered by the police, and consequently that also will have to go, my lord. I have sought for the amendment of the petition, which is a subsequent event, my lord. Please.
Yes. Hmm. Hmm.
Take order of petition number 1.
No,
And
what
that-
is your grievance?
Huh?
What is your grievance?
I'll come to that, madam. What I'm trying to say, background of the case, we will understand it, madam. Therefore, petition number 1 and 2 are one and the same coin. They are the both sides of the coin. Now, I was given a premises to stay there. Now, in order to evict me, instead of going to the HRC proceedings or the civil procedure, which is lengthier procedure, they thought of invoking section 452 of.
Oh, you are working under petition number 1.
I was working.
Huh?
I was working.
When
2016.
2016, R1 was working as
As an executive.
when you resigned.
8/10/2016.
Huh?
8/10/2016.
Until date you are in possession of the same. In which capacity?
I'm in settled position. He is neither a owner nor a licensee.
Who?
The petition number 1 and 2.
No,
The matter
what is your capacity? Why you are in possession?
I am in possession. It was given to me, and it was given in.
That was given to you as an employee.
Not as an employee. Earlier to that. That is why the 2 times the matter was dismissed. After remand also it was dismissed.
No. Why? That is why I asked.
That is what I am trying.
Why the premises was given to you?
No. As far as that is a separate aspect, my lord.
Separate bed.
No, my lord. I'll come to that. I'll come to that.
Premises.
I'll come to that point.
No. Right now you say, in what capacity you entered the premises? Who gave it and for what purpose?
I was inducted into the premises by the second petitioner. The premises belongs to government of Karnataka, the government property, land. Apart from that, the case is no.
Maybe what is your capacity?
No,
what is your? You are not the owner. You are not the owner.
I am not the owner.
Whether government of Karnataka is the owner,
No,
whether petition number 2 is the owner, whether petition number 1 is the owner, but definitely you are not the owner. What is your capacity?
May I make this
2006. Now we are in 26. 10 years. What is your capacity to squat over the property?
My humble submission is, even if I am not the owner of the property, the person who wants to throw me out, he should have some right over the property. If he is not having any right, he cannot ask me.
Directly come to the point. What is your grievance?
My grievance is as far as this case is concerned, my grievance is in order to invoke section 452, they executed exhibit P3, which is a lease deed. The stamp paper was purchased in somebody's name. The date was antedated. Similarly, in order to match the TDS, they executed one more lease deed between the petitioner 2 and petitioner 1, as if it's giving the one more property for 50.
You came to know about that? When you came to know about that?
After filing the case, we filed the RTA application, we got to know.
RTA application with
the stamping authorities of the Tamil Nadu.
Those documents were never produced before any authority?
No, it was produced for the first time in this court.
Which court?
Before the economic offence court.
That in the complaint filed against you.
Yes. In that court thereafter.
That is the lease deed.
That is the lease deed.
Lease deed dated? That is between petition number 1 and 2.
1 and 2.
What is the date of the lease deed?
15/1. This is dated 1/4/2015, Milad. Annexure D, page 62.
Right. That was between petition number 1 and 2. That was produced in the complaint that was filed against you.
Against me said, and again they said that the company has given me as a property as my quarters.
Complaint filed by petition number 1.
Petition number 1.
Against
And,
you.
and the petition 2 acted on because of petition number 1. On the strength of this lease deed, he says that he has inducted me into the premises.
So according to you, the lease deed was concocted, fabricated with an intention to file a complaint against you before the trial court.
Yes.
Right?
Yes.
Why is a bar under 195 is not applicable?
That I'll come back to. I'm submitting a caseless.
Yes.
The first case. Oh,
Why? Tell me
listen,
the
see,
ground on which you are saying
that is
that
what I'm coming, and the caseless are.
No, is it your contention that the bar under 195 is not applicable?
It is not applicable to
Why?
me. Why? Because if the documents were to be in the court custody, and at that time the documents had been tampered with, 195 is applicable. But here is in this case, documents were forged, and the forged documents were given to the court. This offense was not committed during the proceedings of the court.
That is not the requirement of law.
Huh?
That was not the requirement of law.
That is what the first case law says. Supreme Court
Giving
case.
false evidence on the no.
Illa, your lordship kindly read. I will read the first judgment. I'll read the first judgment, my lord.
Fabricating the false evidence on the no.
No, you see, I will read the judgment itself. It declares Supreme Court judgment.
195 section. Giving or fabricating false evidence. According to you, he has given this false evidence, fabricated evidence.
Evidence is talking.
To file and maintain the complaint against you.
My lord, so giving false evidence is deposing in the court.
No. Fabricating false evidence. What does it mean?
No.
What does it mean, fabricating false evidence?
My lord, can I go through the judgment on the same subject? On the same subject, it is not on a different subject.
You have no other argument except relying on this decision.
Huh? No, I have, see what I am.
First argue the matter, thereafter comes this relying on citations.
No, my lord.
In support of your contention.
What I am trying to say is, if the matter is squarely, covered by the judgment, can I not read the judgment?
You are
the judgment. What I am trying to say is, my lord.
You should say, what is your contention? Then to support that contention, you can rely on the judgment.
That is what I am trying to say, my lord.
Not I'm directly saying this is the judgment.
No, my lord, not that way. What I am trying, I said myself clearly, 195 is applicable only when the documents were in the custody of the court. During the custody of the court, if the person fabricates it, tampers it, then that is applicable. But
whether reading of section 195 gives such meaning? According to you, only when the document is concocted, when it was in the custody of the court.
When it is in the custody of the court, during the course of the evidence, if he gives it, that is applicable. That is what the judgment says.
No,
I may be wrong. I may be wrong. If the judge,
Sir, I am trying to understand your point.
that is what I am trying.
Yes. According to you, 195 will be applicable when?
Only when the documents were in the custody of the court and that document is tampered with.
So if a document that is produced before this court is tampered, when it is in the custody of the court, then only it applies, right? If a fabricated document is produced before the court?
It is an offense under the IPC. It is a cognizable offense. Police can take a offense. I can give a police complaint.
Now read the judgment.
Can I read the red note? Prosecution relating to documents given in evidence. Applicability of section
Which is the
195.
paragraph you are reading? Which is the paragraph you are reading?
Short notes. After I go to the paragraph itself.
Paragraph, relevant paragraph. You know, how many judgments you have produced?
Okay, 24, para 25.
How many judgments you have produced? There is no index, nothing.
See, what happened?
How I should find?
I missed it.
No index, no pagination.
I'll do it. Pagination I have given. Pagination I have given. And what has happened, my lord? While coming, I missed it, the entire bunch in the office. I got it printed in the office. By afternoon, I'll give the index also. I'll continue also.
Page number, paragraph number?
Paragraph number, page number 16. In view of the discussion above made, we are of the opinion that Satyananda Singh case has been correctly decided and the view taken by therein is correct. View of section 195B CRPC would be attracted only when the offence enumerated in the said provisions have been committed with respect to a document after it has been produced and given in evidence in a proceedings in any court during the time when the document was in the custody legis. In the present case, the will has been produced in the court subsequently. It is a nobody's case that any offence enumerated in section 1 was committed in respect of the said will after it has been produced and filed before the court of district judge. Therefore, the bar created under section 195 1B2 CRPC would not come into play, and there is no embargo on the power of the court to take cognizance of the offence and the basis of the complaint filed by the respondent. The view taken by the learned additional session judge and the High Court is perfectly correct. Calls for no interference.
What was the offence alleged against
In
the
that
accused
case, in that case, what has happened is a bill was
fabricated.
No, probate was filed.
Huh?
A petition for probate was filed before the court
Yes.
on the basis of forged bill.
That is what?
Then the court took when he filed the case, then the question was, the concerned court alone should file a complaint, not a different complaint. He cannot file a
What
private.
was the offense alleged in that case?
The fabricated bill. Bill is fabricated.
Offense alleged. What was the offense alleged? Section 463,
Yes.
471, 475, 476.
No, my lord, the ratio of dissent is when 195 is applicable. It is
Ratio is to be
195.
applied to the facts of the case.
No, my
The
lord.
facts of the case, it is to be
No,
applied.
my humble submission is,
Now it is your contention, offense under 191, 193, 192, 193, 194, 195 were committed. Here it is a case, the offense under 163, 463, 471, 475, 476 of IPC were committed. Under such facts and circumstances.
my lord, we are not concerned with the offences. We are concerned with whether the same court should file a complaint or complaint can be filed before the private police.
We need not have to consider the facts of the case.
No, the ratio of dissent is one section 195 is applicable, not any other portion. The operative portion.
Argument, sir. Very strange argument. Without considering the facts of the case. Where is the question of applying the ratio?
My lord, the forged deed lease deed were produced before the court. It was forged elsewhere, anterior. Such a case will not come under section 195. That is what this question says. Squarely on the point.
Do you agree that the offense alleged in the said case is under 460, 463, 470?
The list in the court is, this is a proper forum. The list in that matter is not with regard to the offense. Which court has got the jurisdiction to try? That has been decided. His argument is the court, economic offense court alone can try. My argument is I can give a private complaint. The list is not with regard to the offenses.
So irrespective of the offense, this is the ratio decedent according to you?
Yes. This is the matter covered by this court.
Yes, yes.
The next case is page number 17. Satyananda case and another. The same matter has been decided. It has been upheld in this case. This is also forgery only.
Which is the paragraph?
The next case is page number 23.
No, what about the second one?
The second one is been affirmed by the first case. The same provision of law.
Relevant paragraph, sir.
Your offense is 468, 469, 471, para 2.
Para 9, para 8. Para 6. The contention of the appellant is that, page number 19. The contention of the appellant is that if the offence is alleged with respect to the document which reached the court on the above said bar operate, no matter whether the offence was committed before or after its production in the court. In other words, according to the complaint, according to the appellant, directive decisive event for attracting bar is the production of the document in the court. A reading of the clause reveals that two main postulates for mentioned there. First is there must be an allegation that an offence, it should be either an offence described under section 463 or any other offence punishable under section 471, 475, 476 IPC has been committed. Second is that such offence should have been committed in respect of a document produced given in evidence in proceedings before any court. There is a dispute before us that if the forgery has been committed while the document was in custody of the court, then the prosecution can be launched only with the complaint made by that court. There is also no dispute that if the forgery was committed with a document which has not been produced in the court, then the prosecution will lie at the instance of the person. So if so, will its production in a court make all the difference? If even if the clause is capable of two interpretations, we are inclined to choose a narrow interpretation for obvious reasons. Section 190 of the code empowers any magistrate of the first class to take cognizance of any offence upon receiving a complaint or police report or information upon his own knowledge. Section 195 restricts such general powers of the magistrate and general right of a person to move the court if the complaint is to that extent is curtailed. It is well recognized canon of interpretation that a provision curbing the general jurisdiction of the court must normally receive strict interpretation unless the statute or the contract requires otherwise. Therefore, when the general provision is there to empower a magistrate to accept a complaint, section 195 cannot come in the way. That's what the statement is.
Yes.
That apart, it is difficult to interpret section 195 1B2 as containing a bar against initiation of prosecution proceedings merely because document concerned was produced in a court, albeit an act of forgery was prepared prior to its production in the court. Any such construction is likely to ensure unsavory consequences. For instance, if a rank forgery valuable document is detected and for forger is sure that you would imminently be embroiled in a prosecution proceedings, he can simply get the document produced in any long-term litigation which was neither initiated by him or somebody else who can be influenced by him, and thereby preempt the prosecution for the entire long period of pendency of the litigation. It is a settled proposition that if the language of a legislation is capable of more than one interpretation, the one which is capable of causing mischievous consequences should be averted. Quoting from Gill versus Donald Company has stated in his thesis of interpreting a statute that if the language is capable of more than one interpretation, we ought to discard more natural meaning to it. It leads to unreasonable result. Adopt that interpretation which leads to reasonably practicable result. The costs which are now considering the contents enough indication to show that more natural meaning is that which learns in our favor the strict consideration. Hence, the above said observation is eminently applicable here.
Yes. Next.
My lord, I'm getting tired of. Can I take it up in the afternoon?
Why, sir?
I don't know. It's fully tied up. I'm not able to talk. I'll take it up in the afternoon.
Yes, 2:30.
Serial number 15, NG Sridhar, NV Murthy.
Lord, in fact,
1 minute. Yes.
And for the petitioners, my lord, on 24th January 25, in fact, there is an order on these applications to be considered at the time of hearing on the main petition itself.
Amendment application.
Amendment application. There it was filed pursuant to subsequent developments, my lord. Like even despite there being stay order, they proceeded to register an charge sheet. And to comprehend that CC number, my lord, I have sought for an amendment as an additional prayer, even the proceedings pursuant to that be quashed.
Yes. Yes, proceed on merits. But
Yes, ma'am.
applications are also pending along with that will be considered along with merits.
Main, yes, yes. Here, my lord, the offences that have been alleged is section 498A of IPC read with section 3 and 4 of the
Who is the
Prohibition.
petitioner? Petitioners are?
Petitioners, the first petitioner, my lord, is the husband.
Accused number?
Accused number 1.
No, there are how many petitioners?
There are 4, my lord.
Who are they?
One is the first petitioner is the husband of respondent 2.
Yes.
The second petitioner, my lord, is the mother-in-law, my lord.
Yes.
The third petitioner is the father-in-law. And the fourth petitioner is the brother-in-law.
ಏನಾಗಿದೆ respondent number 2?
I am for the respondent.
Offense alleged 498A.
And section 3 and 4 of dowry prohibition.
Date of marriage?
Date of marriage, my lord, is 20th June 2015, my lord.
Date of complaint?
Date of complaint, my lord, is 22nd April 2021. There are certain very pertinent developments between these two dates, my lord.
Yes.
The first one, my lord, the child is born to them, a daughter, on 18th November 2015. My lord.
18th?
November 2015.
A daughter is born.
Yes, my lord. And she is named Shravya.
Oh.
My lord, on 16/7/2016, my lord. I'm sorry, 16/5/2016.
ಇದು ಡೇಟ್ ಕರೆಕ್ಟ್ ನಿಮ್ದು 18/11/2015.
ಹೌದು ಸ್ವಾಮಿ.
Date of birth?
Yes, yes. Date of birth of the 1 second. my lord. Yes, yes. Especially it looks. I'll extricate it from the petition what I filed. Miscellaneous.
Date of marriage is January 29, 2015. Correct, sir?
January, yeah. 20th marriage between
January
the solemnized on 20th June ಅಂತಿದೆ.
29th January 2015, my lordship. In the FIR it is
20th January.
29th January 2015.
So date of birth of the daughter is
18/11/2015. Then yes, yes. I'm sorry, my lord. And on 16th May 2016, my lord, the respondent too, with the child, she walked out from the family, from the matrimonial home. 16th May 2016.
Is it admitted facts or disputed facts?
It's admitted, my lord. Later it got compromised before matrimonial, in the family court in a matrimonial case. After she walked out, within 2 months thereof, the husband, that is petition number 1, issued a legal notice calling upon her to come and join the matrimonial home.
Legal notice was issued.
16/7/2016, Annexure B I have enclosed, my lord. Then, having not responded to that, my lord, and certain mediations or reconciliation meetings took place between them through their respective councils who exchanged these notices and reply.
Then
Then on 25th January 2017, my lord, the husband, that is petition number 1, filed a matrimonial case in MC number 521 of 2017
for
for restitution of conjugal rights.
Yes.
And that petition is at Annexure C, my lord.
Yes, then.
And she entered appearance on record, my lord, in this case, the respondent too, and on 15/7/2017, my lord.
15.
7/2017.
Hmm.
Both of them, through their respective councils, filed a petition under Order 23, Rule 3 of CPC, compromise, filing a compromise petition.
What is the compromise?
Compromise is that she had to return back to the matrimonial home, and she has made certain undertakings which are very pertinent to be considered by this honorable court, my lord, because it speaks about her conduct, not only about the one which was prevailing earlier to this compromise, and the conduct to be regulated after this compromise also, my lord. It
Compromise petition annexure.
is at Annexure E, my lord.
Then.
Annexure D, I think.
Then then after that, on 11/4/2021, my lord, she walked out of the matrimonial home.
11/4.
2021, my lord, and came back with police from Subramaniapura police station. And she vacated with all her belongings on 11/4/2021. And on 12/4/2021, both of them were relegated, that is respondent 2 and petition number 1 were relegated to the Basungudi Women's Police Station, my lord, saying that you will have to go and appear before them for further proceedings. So the petitioner number 1, my lord, he appeared before the Basungudi Police Station at 11 a.m. on 12/4/2021, and he was subjected to interrogation up to 4:30 p.m. on the same day, my lord. And on the
Which police station?
Basungudi Women's Police Station, my lord.
No, already the complaint was filed.
No, my lord. It was not filed as on that day. From Subramaniapura police station, orally they were directed to go and appear before Basungudi police. And on 12/4, he appeared before the Basungudi police. And from 11 a.m. to 4:30 p.m., he was made to stay in the police station, my lord. And on 12/4, they issued a notice saying that not only to the petitioner number 1, but also to the wife, respondent number 2, to appear before the Mahila Sahayavani Santvana Kendra. I have enclosed that, my lord, also. Annexure F.
Yes.
And on 13/4, the petitioner number 1 husband interacted with the Mahila Sayavani Kendra, but they told due to COVID-19 pandemic, we will call you after 5th of May. We will call you. Till then, you will have to wait. That's what they told, my lord. But what happened was on 14/4, my lord. On 14/4, the respondent 1 police, my lord, informed petition number 1 to appear before them on 17th of April over phone, my lord. And on 17th of April, he appeared before the police station, Basungudi Women's Police. And even on that day also, my lord, he was subjected to, for a long time, he was made to sit in the station. And eventually, while he was being sent out, they served a notice on him to appear on 19/4/2021. Annexure G, my lord. And on 19/4/2021, he once again appeared before the Basungudi Women Police Station, and he was made to sit for a long time there, and eventually while he was being sent out, they issued one more notice, Annexure H, asking him to appear on 22/4/2021.
Whether respondent number 1 was also appearing? Respondent number 2, sorry. She also appeared? No.
No, no, my lord, not respondent to, only
So
respondent.
you appeared before this Mahila Sahaya Vani?
Only that notice was given to her, not all other notices.
12/4/2021.
Yes.
Again on 17/4.
Yes, my lord. Again on 19/4, my lord.
19/4 and on 22/4.
And he was asked to appear on 22/4. On which day, my lord, they had till then the complaint was not registered. Till then the complaint was not registered.
Complaint was dated?
Complaint was also, it is undated, my lord. It doesn't bear any date. Your lordship will see.
Registered on 22/4.
Yes, my lord. Annexure J is the complaint, ink page 59, my lord. It doesn't bear any date as such. In the last page, at ink page 64, your lordships will find an endorsement made by respondent 1, having received it on 22nd April at about 2 p.m. My lord, no, my lord, I would like to pause before giving other events, subsequent events, my lord. I would like to pause, and here I would like to mention that in all these notices, your lordships will find it has been issued only to petitioner number 1, my lord, not to any other petitioners. And on all these dates of hearing on which they required him to visit the police station for investigation, my lord, he was made to agree, he was rather forced to agree for a proposition that either he will make arrangement for a separate residence, or he will pay 50 lakhs of rupees as a permanent alimony to the respondent number 2, for which he did not succumb on all these 3 occasions. He has been telling that absolutely there is no fault on his part, and he tried to justify himself and of the position of his parents and also his brother. And eventually, when they realized that he is not succumbing to these illegal dictates and demands of respondent 2 in collaboration with respondent 1, my lord, they have decided to register the FIR on 22nd of April. Till such time, now the question is, were they authorized to summon petition number 1 to police station? There being
Now, what is the allegation?
Allegation is very bald, my lord, and very ambiguous, vague, and omnibus, my lord, so as to rather exaggerated to comprehend even the period during the marriage.
Where is the complaint?
Annexure J, my lord,
Page number.
ink page 59. And before we read the complaint, my lord, may I invite your lordship's kind attention to the compromise petition that was filed, because it comprehends certain crucial undertakings that were made by the respondent number 2 before the family court, my lord. Ink page 51 may kindly be seen. That's the typed page of the compromise petition, which is enclosed as Annexure D, my lord. Page 51, my lord.
Yes.
My lord, here the the respondent wife, may I read, my lord?
Yes.
The condition number 1, my lord. The respondent wife, in clear and unequivocal terms, concedes the prayer sought for by the petitioner in the above case, and hereby asserts that she has no objection whatsoever for this honorable court to decree the above petition as prayed for. The respondent wife hereby undertakes to restore the petitioner's conjugal rights by joining back along with the child with the petitioner at his house, which is now situated at number so and so, Bangalore. The respondent wife undertakes that she shall continue to stay with the petitioner and his parents by discharging responsibilities as that of wife, daughter-in-law, and as mother of the child, and without causing prejudice to these responsibilities. The respondent covenants that she shall seek for new job in nearby place to the petitioner's house, for which the petitioner has no manner of objection whatsoever. The respondent wife covenants that she shall henceforth, without genuine reason, shall not intermittently visit her mother's place with the child and or stay at mother's place, and that she undertakes to do her best to conduct herself so as to uphold the status and dignity of the petitioner and his parents, and also undertakes to develop the child's relationship with the petitioner and his parents in the interest of the welfare of the minor child. In the event that the respondent fails to join the petitioner at the address shown herein above, the petitioner is at liberty to take all appropriate steps as are available in law for appropriate relief before court of law. The petitioner covenants that he shall continue to conduct in the manner to uphold the status and dignity of the respondent wife, and that he shall continue to extend all cooperation to the respondent wife for enabling her to discharge her responsibilities as aforesaid at paragraph number 3 supra. And both of them have entered into out of free will. That's what the next para says. And now, your lordship may read the complaint, my lord, annexure J. And this is about 4 years thereafter, my lord. This is 4 years thereafter. And in the subject, she says, complaint against my husband, Sri Harsha, my mother-in-law, my father-in-law, and brother-in-law, so and so, for mental and physical harassment. With respect to above, I got married to Sri Harsha.
It runs into several pages. You
Yes, my lord.
Go on reading this. You should say in nutshell what is the allegation.
In nutshell, my lord, she says they were throwing tantrums on her, and they were saying, for breakfast you must have only so much of food, and you and your child leave the home by giving mutual consent divorce. And that she says in one paragraph, and very next paragraph she says the parents-in-law are insisting to leave the child and for her to go to her mother's place, to leave the child at the matrimonial home, and then she will go to the mother's place. So these are certain contradictions inherently available in this complaint, my lord. And it's only a recrimination against the mother-in-law. Dominantly, it's a recrimination made by this respondent number 2 as a daughter-in-law against the mother-in-law.
Yes.
And she doesn't say anywhere when she makes allegations about some dowry harassment in the garb of dowry, what are the quantified demands or qualified demands from the petitioner side. She nowhere substantiates in the complaint, my lord. It's just an omnibus allegations made by using all adjectives, my lord, to say that they have been harassing physically, they have been harassing mentally, without saying what are those incidents which has caused physical and mental harassment. No details as to the date or to the or of the incident as to what has caused mental and physical cruelty. ಏನು ಹೊಡೋದ್ರ ಇದು ವರ್ಬಲ್ ಅಬ್ಯೂಸು, ಯೂಸಿಂಗ್ ಬ್ಯಾಡ್ ವರ್ಡ್ಸು ಈ ತರ ಹೇಳ್ತಾರೆ ಬಿಟ್ರೆ ಏನದು. ಆಮೇಲೆ ಫಿಸಿಕಲ್ ಹರಾಸ್ಮೆಂಟ್ ಅಂತಾರೆ. ಯಾರು ಹೊಡೋದ್ರು ಅದು ಹೇಳಿಲ್ಲ ಎಲ್ಲೂ. ಹೂ ಹ್ಯಾಸ್ ಮೇಡ್ ಫಿಸಿಕಲ್ ಹರಾಸ್ಮೆಂಟ್? ದೇರ್ ಆರ್ ನೋ ಡೀಟೇಲ್ಸ್. And the pith and substance of the complaint, she says, the petitioners are insisting her to give divorce by mutual consent and asking her to go out of the matrimonial home. My lord, it goes quite absurd and unbelievable, my lord, when the petitioner, number one, has compromised before the family court, seeking for her, for the restitution of conjugal rights, and for her to come back with the child and to endure the life with the solace and comfort of his wife and child, with his parents, my lord. These kind of allegations goes quite contrary, my lord. The petitioner number one, my lord, is an MBA graduate. He is a human relation head in a private company, my lord. And she is in the teaching faculty of a school. And she holds about 3 master degrees.
Where the child is residing?
The child is with the mother right now, my lord.
They are residing separately.
She is in her mother's place, my lord.
Mother's place.
Mother's place.
Are you giving anything to the child?
Yes, yes, my lord. Before the court, there is an interim order in the matrimonial case. Now, my lord, after all these developments, the husband has filed a matrimonial case seeking for a dissolution of the marriage.
When that was filed?
That was filed on June 2020, 30th June 2021, my lord.
21.
Yes, my lord. MC number 2971 of 2021. 2971 of 2021, my lord. And in that case, my lord, there is an interim order directing him to pay maintenance to her and as well to the child, my lord. And she has rather, in fact, suppressed that she is gainfully employed before the trial court. And the trial court summoned certain documents from educational institutions and came to a conclusion that she is working. And then an order was passed granting maintenance pending.
Only to the child?
Not to, even to her also, my lord.
Both.
Both, my lord.
What is the?
He is paying 35,000 per month, my lord.
Together?
Together, yes. Apart from that, even education expenses he is reimbursing.
Yes, what is it?
Your Lordship, the present case, Your Lordship, the complaint has been lodged on 11/4/2021. The police have not filed FIR immediately after lodging the complaint. Kindly see, the FIR has been lodged on 22/4/2021. After conducting the preliminary inquiry and sending both the parties to the mediation, and they have come to the conclusion that the offense which have been alleged in the complaint is
When you filed the complaint?
11/4/2021, Your Lordship. And on the very next day, both the parties have been sent to for mediation, which have been produced by my learned friend at Annexure F, wherein you kindly see Annexure F, which is dated 12/4/2021. ಈ ಮೂಲಕ ತಮಗೆ ತಿಳಿಪಡಿಸುವುದೇನೆಂದರೆ, ನೀವು ಕೌಟುಂಬಿಕ ಸಮಸ್ಯೆ ಕುರಿತು ಬಸವನಗುಡಿ ಮಹಿಳಾ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ದೂರು ನೀಡಿದ್ದು ಅದರಂತೆ ನೀವು ನಿಮ್ಮ ಕೌಟುಂಬಿಕ ಸಮಸ್ಯೆಯನ್ನು ಮಾನ್ಯ ಡಿಜಿ ಐಜಿಪಿ ರವರ ಸುತ್ತೋಲೆ ನಂಬರ್ ಸೋನ್ಸೋರಂತೆ ನೀವು ನಿಮ್ಮ ಸಮಸ್ಯೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪರಿಹಾರ ವನಿತಾ ಸಹಾಯವಾಣಿ ಸಾಂತ್ವನ ಕೇಂದ್ರ ಬಸವನಗುಡಿ ಬೆಂಗಳೂರು ನಗರ ಇಲ್ಲಿ ಕೌಟುಂಬಿಕ ಸಮಾಲೋಚನೆಯನ್ನು ಪಡೆದು ನಿಮ್ಮ ಕೌಟುಂಬಿಕ ಸಮಸ್ಯೆಯನ್ನು ಬಗೆಹರಿಸಿಕೊಳ್ಳಲು ಕೇಳಲಾಗಿದೆ. Immediately after filing the complaint, they have not
They are not supposed to, sir.
Yes, Your Worship. In view of the guidelines issued by this Honorable Supreme Court, they have to conduct some preliminary inquiry. Later on, they come to the conclusion that the allegation made by the respondent number 2 is a genuine one. Therefore, on 22/4/2021, they filed a FIR. Your Worship, kindly see, subsequent to the filing of the FIR, the investigation has been conducted and charge sheet have been filed. Charge sheet have been filed on 5/7/2021 prior to filing of this writ petition.
Where is the final report?
Final report has been produced by along with the application. Application hakidare Swami. Amendment application hakidare. Along with the amendment application, they have produced at page number 10.
It's not 5/7, what my learned friend
ಒಂದು
says,
ನಿಮಿಷ,
it's
ಒಂದು ನಿಮಿಷ.
28/7.
ನೀವು ಆಮೇಲೆ ಹೇಳಿ ಏನ್ ಹೇಳ್ತೀರಿ ಹೇಳಿ.
ಎಲ್ಲಿದೆ ಇದು?
Charge sheet have been produced at page number 10 which has been filed along with the application.
I have a copy.
ಇದು the paper book which contains IA 2 and 3, my lord. It also contains memo of additional documents.
Correct.
In that, your lordship will find.
At page 10, Your Lordship. The charge sheet has been filed on 5/7/2021.
Yes.
27/7, it has been the court has making a report that it has been taken on record anteli. Charge sheet date is very clear, Your Lordship, in the first sheet of the charge sheet. First sheet of the charge sheet, Your Lordship. At 27/7 antali court receive ಮಾಡ್ಕೊಂಡಿರೋದು ಅದ್ರ ಮೇಲ್ಗಡೆನೇ ಇದೆ ಸ್ವಾಮಿ. Charge sheet ಸಂಖ್ಯೆ 82/2021, charge sheet dated 5/7/2021.
Was prepared, the charge sheet was prepared by the investigating officer on 5/7.
Yes, 5/7.
But it was
And it has been sent to the court.
Submitted to the court on 27/7.
Please, Your Lordship.
Yes.
So kindly
And
see
same day there was an
in the
interim
charge
order of
sheet, Your
stay.
Lordship, kindly see, neither the respondent petition number 1 nor the other accused have been arrested. Kindly see the page number 2 of the charge sheet, page 11.
So there is a bar for arresting.
Yes, Your Lordship. Absolutely. The
For
police have
matrimonial-
investigated.
Criminal offense.
Yes, Your Lordship. Police have investigated this case in a proper manner and before filing a FIR, they have conducted all preliminary inquiries.
Come to what is this?
Complaint, I will.
Last para number 17 at page number 18, the gist of the allegations as per the charge sheet.
ಕೇಸಿನ ಸಂಕ್ಷಿಪ್ತ ಸಾರಾಂಶ. ಸಾಕ್ಷಿ 1 ರವರಿಗೆ ಆರೋಪಿಯೊಂದಿಗೆ ದಿನಾಂಕ 29/1/2015 ವೆಸ್ಟ್ ಆಫ್ ಕಾರ್ಡ್ ರೋಡ್ ರಸ್ತೆಯ ವೀರುಬಾಯಿ ಕಲ್ಯಾಣ ಮಂಟಪದಲ್ಲಿ ಹಿಂದೂ ಸಂಪ್ರದಾಯದಂತೆ ಮದುವೆ ಆಗಿದ್ದು, ಮದುವೆ ಸಂಬಂಧವು ಮ್ಯಾಟ್ರಿಮೋನಿಯಲ್ ನಲ್ಲಿ ಬಂದಿದ್ದು, ಮದುವೆ ಮಾತುಕತೆಯಲ್ಲಿ A1, A2, A3, A4 ಆರೋಪಿಗಳು ಚೆನ್ನಾಗಿ ಮದುವೆಯನ್ನು ಮಾಡಿಕೊಡಿ ಅಷ್ಟೇ ಸಾಕು ಎಂದು ಹೇಳಿದ್ದು, ನಂತರದಲ್ಲಿ ಆರೋಪಿಗಳು ಸಾಕ್ಷಿ 1 ರವರಿಗೆ 150 ಗ್ರಾಂ ಚಿನ್ನದ ಒಡವೆ ಕೊಡಬೇಕು ಮತ್ತು A1 ಆರೋಪಿ ವಾಚು, ಚಿನ್ನದ ಸರ, ಉಂಗುರ ಮತ್ತು ಬೆಳ್ಳಿ ಪೂಜಾ ಸಾಮಗ್ರಿಗಳ ಸೆಟ್ಟು, ಮಂಚ, ಫ್ರಿಡ್ಜು, ಬೀರು ಇತ್ಯಾದಿ ಗೃಹ ಉಪಯೋಗಿ ವಸ್ತುಗಳನ್ನು ಕೊಡಬೇಕೆಂದು ಒತ್ತಾಯ ಮಾಡಿ ತೆಗೆದುಕೊಂಡಿದ್ದು, ಮದುವೆಯ ನಂತರದಲ್ಲಿ ಚಿಕ್ಕಲ್ಲಸಂದ್ರ ಬಾಡಿಗೆ ಮನೆಯಲ್ಲಿ ಸಾಕ್ಷಿ 1 ರವರು A1, A2, A3, A4 ಆರೋಪಿಗಳೊಂದಿಗೆ ವಾಸ ಮಾಡಿಕೊಂಡಿದ್ದಾಗ ಸಣ್ಣ ಪುಟ್ಟ ವಿಚಾರಗಳಿಗೆ ಜಗಳ ತೆಗೆದು ಸಾಕ್ಷಿ 1 ರವರಿಗೆ ಬೈಯುತ್ತಿದ್ದು, ಇದಕ್ಕೆ ಉಳಿದ ಆರೋಪಿಗಳು ಕುಮ್ಮುಕು ಕೊಟ್ಟು ಚುಚ್ಚು ಮಾತುಗಳನ್ನಾಡುತ್ತಿದ್ದು, ಸಾಕ್ಷಿ 1 ರವರಿಗೆ ಸರಿಯಾಗಿ ಊಟ ತಿಂಡಿಯನ್ನು ಕೊಡದೆ, ಖರ್ಚಿಗೆ ಹಣವನ್ನು ಸಹ ಕೊಡದೆ ಕೆಲಸಕ್ಕೆ ಹೋಗಲು ಬಿಟ್ಟಿರುವುದಿಲ್ಲ. ನಂತರದಲ್ಲಿ ಸಾಕ್ಷಿ 1ರವರು ಗರ್ಭಿಣಿ ಆಗಿದ್ದು ಮನೆಯ ಎಲ್ಲಾ ಕೆಲಸಗಳನ್ನು ಸಾಕ್ಷಿ 1ರವರ ಕೈಯಲ್ಲಿಯೇ ಮಾಡಿಸಿರುತ್ತಾರೆ. ನಂತರದಲ್ಲಿ ಸಾಕ್ಷಿ 1ರವರು ಹೆಣ್ಣು ಮಗುವಾಗಿದ್ದು 11 ದಿನಗಳಿಗೆ ಮಗುವನ್ನು ಮತ್ತು ಸಾಕ್ಷಿ 1ರವರನ್ನು ಗಂಡನ ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದು ಸಾಕ್ಷಿ ಅಂದ್ರೆ 11 ದಿವಸಕ್ಕೆ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ. ಸಾಕ್ಷಿ 1ರವರ ಮತ್ತು ಮಗುವಿನ ಯಾವುದೇ ಜವಾಬ್ದಾರಿಯನ್ನು ನೋಡಿಕೊಳ್ಳದೆ ಆಗ್ಬೇಕಾಗಿತ್ತು, ನೀಡಿಕೊಳ್ಳದೆ ಅಂತಾಗಿದೆ. ಸಾಕ್ಷಿ 1ರವರು ಕೆಲಸಕ್ಕೆ ಹೋಗಲು ಶುರು ಮಾಡಿದ್ದಕ್ಕೆ ಎಲ್ಲ ಆರೋಪಿಗಳು ಸೇರಿಕೊಂಡು ಜಗಳ ಮಾಡಿ ಸಾಕ್ಷಿ 1ರವರು ಮತ್ತು ಮಗುವನ್ನು ಮನೆಯಿಂದ ಹೊರಗೆ ಹಾಕಿದ್ದು, ಇಬ್ಬರು ಕೌಟುಂಬಿಕ ಸಮಸ್ಯೆ ಬಗ್ಗೆ ಕೌಟುಂಬಿಕ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಮಾಲೋಚನೆಯನ್ನು ಮಾಡಿ ಇಬ್ಬರನ್ನು ಜೊತೆ ಮಾಡಿ ಕಳಿಸಿದ್ದು, ಸಾಕ್ಷಿ 1ರವರು ವಾಪಸ್ ಗಂಡನ ಮನೆಗೆ ಹೋಗಿರುವಾಗ 2ನೇ ಮಗುವಿನ ಗರ್ಭಿಣಿ ಆಗಿದ್ದು, ಆರೋಪಿ ನಂಬರ್ 1 ಆರೋಪಿಯು ನಿನಗೆ ಇನ್ನೊಂದು ಮಗುವನ್ನು ಸಾಕಲು ಯೋಗ್ಯತೆ ಇಲ್ಲ ಎಂದು ಜಗಳ ಮಾಡಿ ಅಬಾರ್ಷನ್ ಮಾಡಿಸಿರುತ್ತಾರೆ. ಆರೋಪಿ 1 ಆರೋಪಿಗೆ ಕುಮ್ಮಕ್ಕು ನೀಡಿ ಸಾಕ್ಷಿ 1ರವರಿಗೆ ಜಗಳ ಮಾಡಿ ಹೊಡಿಸಿದ್ದು ದಿನಾಂಕ 8/4/2021 ಅವಳ ಗಂಡನ ಮನೆಯವರೆಲ್ಲ ಸೇರಿಕೊಂಡು ಸಾಕ್ಷಿ 1ರವರನ್ನು ಮನೆಯಿಂದ ಹೊರಗೆ ಕಳಿಸಿದ್ದು, ನಂತರದಲ್ಲಿ 11/4/2021 ಸಾಕ್ಷಿ 1ರವರು ವಾಪಸ್ ಗಂಡನ ಮನೆಗೆ ಹೋದಾಗ ಸಾಕ್ಷಿ 1ರವರನ್ನು ಮತ್ತು ಮಗುವನ್ನು ಮನೆಗೆ ಸೇರಿಸದೇ ಇದ್ದು, ಸಾಕ್ಷಿ 1ರವರಿಗೆ ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆಗಾಗಿ ಗಂಡ, ಅತ್ತೆ, ಮಾವ ಮತ್ತು ಮೈದುನರವರುಗಳು ದೈಹಿಕವಾಗಿ ಮತ್ತು ಮಾನಸಿಕವಾಗಿ ಕಿರುಕುಳ ನೀಡಿರುವುದು ತನಿಖೆಯಲ್ಲಿ ಲಭ್ಯವಾದ ಸಾಕ್ಷ್ಯಾಧಾರಗಳಿಂದ ದೃಢಪಟ್ಟಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಆರೋಪಿಗಳ ವಿರುದ್ಧ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ದೋಷಾರೋಪ ಪಟ್ಟಿಯನ್ನು ಸಲ್ಲಿಸಲಾಗಿದೆ. You will have to kindly see the complaint.
If there was a demand for dowry and additional dowry,
yes, you are.
that should have been found a place in the compromise petition.
I may be permitted to read the complaint, Your Lordship.
No. The parties have entered into compromise.
Compromise, that too immediately after the delivery of the child.
Maybe.
That is in the year
Maybe
2000.
Willingly
Yes, Your
you
Lordship.
signed, you are party to the compromise petition. There is no such allegations. When the marriage had taken place.
Allah. I may be permitted to the return statement filed by the wife by the next date of hearing in the earlier MC case.
Sir, I am asking you, marriage is of the January 2015.
Please, Your Lordship.
According to you, at the time of marriage, there was demand for dowry, which you are not willing. And somehow you are forced to pay that gold, jewelry,
Please, Your
and
Lordship.
marriage expenses, everything. If that was the case, where is the question of you staying with the petitioners for so long?
Because I don't want to separate from my husband, Your Lordship. I want to continue with him.
Yes,
Your
if
Lordship.
that is the case,
Your
if
Lordship.
that is the case,
Yes.
once you left the house, matrimonial house, along with your child,
It is not, with my free will, I am not,
let us
they have
assume
not thrown.
they were forced you to
Yes.
leave the house, right?
Yes, Your Lordship.
Thereafter, a petition for restitution of conjugal right was filed. A compromise was entered into. There is no whisper about any of these dowry harassment, dowry demand.
Even at the
Why?
time of marriage, Your Lordship, she was
Sir,
what?
you are represented by an advocate. Respondent number 2 was represented by an advocate in that restitution of conjugal right petition. And willingly you entered into a compromise.
With an intention that they will look after me in the near future.
Let them
in the
look
future.
after. There are certain conditions to both the parties. But unfortunately, there is no whisper about this demand for dowry, payment of dowry, additional dowry, and all that.
ಅಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಅದೆಲ್ಲ ಹಾಕಿದ್ರೆ ಏನಾಗುತ್ತೆ, ಕಾಂಪ್ರಮೈಸೇ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ, ನನ್ನ ಮನೆಯೊಳಗೆ ಸೇರಿಸ್ಕೊಳ್ಳಲ್ಲ, ಅದು ದಟ್ ಈಸ್ ದ ಸಮಸ್ಯೆ.
Allegations, what I am saying is there must be allegation at the initial stage. At the initial stage.
Yes, Your Lordship.
Why after so long?
No.
15 ನಲ್ಲಿ ಆಗಿದ್ದು 21 ನಲ್ಲಿ why that allegation?
They have
came suddenly?
produced only a compromise petition before this honorable court to show that there is no allegation. I may be permitted to produce the return statement.
Prevented you, sir?
Yes, Your Lordship.
Who prevented you?
I will produce, Your Lordship.
He has already produced. If that was your case, that she has already taken a stand, you could have produced it.
I will
After
produce
hearing
it.
all the argument, you cannot say, I may be permitted. I will produce. Why not produced all these
Initially,
days?
that some other advocates were looking after these cases, Your
Don't
Worship.
blame
I
others.
know that this is
Now
not the ground.
you are the advocate who is
This is not the
representing.
ground to seek.
It is easy to blame some other, your brother or
Yes, Your
sister advocate. No, don't take such stand. Now you are representing respondent number 2 and you are answerable to that.
Look, kindly see, also, I will take Your Lordship 2 or 3 paragraphs of the complaint which have been filed by me.
Yes, I have gone through that. I have gone through that and the charge sheet also column number 17 I have seen. Except making bald allegations against this accused number 224. ಕುಮ್ಮಕ್ಕು ಕೊಟ್ರು
ಇಲ್ಲ
ಏನು ಚುಚ್ಚಿ ಮಾತಾಡಿದ್ರು ಅಷ್ಟೇ.
Illa Swami, even in the complaint itself, it is very clearly stated that even they have not provided a proper food when I was pregnant. Even after the delivery, they refused to give a food to my child also. And they forced me to go out of the matrimonial home.
The restitution of conjugal rights proceedings was held much after delivery, first delivery.
Yes, even after subsequent to the delivery also. So when that respondent, the second respondent has voluntarily, without making any allegation against his husband, with an intention that they will look after her and her children.
Petition number 1 is residing with petitioners 2 to 4.
Yes.
Yes, my lord, yes.
They are residing
Yes,
together.
both are very old, my lord. Now, when the complaint was filed itself.
What about accused number 4?
Accused number.
He is separately.
He is also.
He is
residing in
married
the
and
same.
now he is separate.
So only in-laws are residing together.
Yes, yes.
When accused number 4 was married?
My lord, somewhere in the year 2022, my lord.
Before filing the complaint or after?
After filing the complaint.
Accused number 4 is also residing along with wife in the same house as on today.
ಬಟ್ ಅವ್ರಿಗೂ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಗೆಲ್ಲ ಬಹಳ ತೊಂದರೆ ಆಯ್ತು ಸ್ವಾಮಿ FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದೆಲ್ಲ. Then after stay order was produced
Whether
before
now
that.
she is working? No.
No, Your Lordship.
Why?
Because it is their condition that I should not work anywhere.
Now,
Yes, now also she is not working.
Care for their
Now also she is not working anywhere, Your Lordship.
Why?
Because she resigned her job in the year 2021, immediately after the marriage.
So according to him, you are a master degree holder.
Admittedly, I am a master degree owner. I am completed my MA.
But not interested in working.
Not, I'm trying to gain a job, but I could not able to succeed.
For all these years.
Yes, Your Lordship. I tried my level best, but unfortunately, I could not secure the job.
Very sad state of affairs.
I could not secure the job.
You are satisfied
And
with the
meanwhile, Your Lordship, immediately after filing the complaint, as a counterblast, they filed a case for divorce
Yes.
under section 13(1)(a).
That is still pending.
Yes, still pending. It's going and evidence is going
Evidence
on.
is
And
there.
cross-examination.
They
is
have
also
to
going on.
cross-examine the.
You are not willing to give divorce.
ಅದು ಗೊತ್ತಿಲ್ಲ, ಕಾಂಪ್ರಮೈಸ್ ಗೂ ಕೂಡ ರೆಫರ್
ಅಲ್ಲಿ
ಆಗಿತ್ತು, ಮೀಡಿಯೇಷನ್ ಹೋಗಿತ್ತು.
ಈಗ 1 ಕೋಟಿ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. 1 ಕೋಟಿ ಕೊಟ್ರೆ ನಾನು
ಅಲ್ಲ, ಮೀಡಿಯೇಷನ್ ಗೂ ಹೋಗಿತ್ತು.
ಇವನ್ ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆ ರೀತಿ ಸಬ್ಮಿಷನ್
ಮೀಡಿಯೇಷನ್ ಹೋದಾಗ A3 is none other than my father-in-law. Even during the existence of marriage, when the wife is residing along with in-laws house, he is forcing that ನೀವು ಅವಳಿಗೆ ಮ್ಯೂಚುವಲ್ ಡೈವರ್ಸ್ ಕೊಟ್ಬಿಡಮ್ಮ, ನಿನ್ಗೆ 50 ಲಕ್ಷ ಕೊಡ್ತೀನಿ, 50 ಲಕ್ಷ ಕೊಡಿಸ್ಕೊಡ್ತೀನಿ ಅಂತ. ಈ ಹಿಮ್ಸೆಲ್ಫ್ ಫೋರ್ಸಿಂಗ್ the accused number 1 and accused number 3.
Something ridiculous.
It's all false allegation made against.
When such
Your Lordship, kindly see the complaint itself.
ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ ಎಲ್ಲ ಇರುತ್ತೆ ಸರ್, A to Z ಇರುತ್ತೆ.
ಹೌದು ಸರ್.
ಇಂತ ಅಲಿಗೇಷನ್ಸ್ ಹೇಗ್ ಮಾಡ್ಬೇಕು ಅನ್ನುವಂಥದ್ದು
ಇಲ್ಲ ಆತರ ಇಲ್ಲ. This is in this case, Your Lordship.
Fortunately, similar allegations and one more allegation of sexual harassment against the father-in-law. We are seeing that latest development to make it very strong. Where we are heading, we do not know. Only to see that something is done.
It's all false allegation which they have made. Non-demand madidini anteli. It is not the demand of the wife. They themselves forcing her to give a divorce,
in the
mutual
open-
divorce.
in
We
the
will
o-
settle for sum of rupees 50 lakhs. If you give the mutual divorce, we will give 50 lakhs rupees. This is how they are forcing the.
What is your stand?
Gottilla, you can keep the respondent before December court.
I am not interested in mediating.
In fact, the family court, my lord, spoke with both the parties, and she was demanding in the open court, 1 ಕೋಟಿ ಕೊಟ್ರೆ ನಾನು ಸೈನ್ ಮಾಡ್ತೀನಿ ಡೈವರ್ಸ್ಗೆ. This was the words, and even court got annoyed hearing to this, and in fact it deprecated her conduct. ಹೀಗಲ್ಲ, something you resolve.
Yes, proceed on merits.
ಅದೇ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಒಂದೇ ಒಂದು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಒಂದು ನಾನು ಕಾಪಿ ಕೊಡ್ತೀನಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಂಡ್ರೆ ಐ ವಿಲ್ ಸಿ ದಟ್ ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಅಲಾಂಗ್ ವಿತ್
ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋದು ಇಲ್ಲ.
ಯಾಕಂದ್ರೆ ಐ ಡೋಂಟ್ ವಾಂಟ್
ಯೂಸ್ ಟು ಸಚ್ ಪ್ರಾಕ್ಟೀಸ್. ಒಂದ್ಸಲ ಆರ್ಗ್ಯುಮೆಂಟ್ once I take up, it should conclude.
2 days time may be granted because I will please allow me to produce the return statement which have been filed by the respondent number 2 in
Ask
the
you
MC case.
who prevented you from producing. Is there any bar? Whether the court rejected your prayer for production of documents, you know what is the document, what are all the documents he has produced. If at all there was supporting document, it was your duty to produce it. Why should I call upon and permit you?
I may be permitted to read the relevant portion of the complaint where the several allegation where they have forced us to leave the matrimonial home. Page 60, Your Lordship. Page 60, para 1. My mother, with the support of her brothers, this is a complaint filed by the complainant, R2. My mother, with the support of her brother, have performed our marriage in a grand manner, considering that we will lead a happy life, and that at that time of marriage, my happy life, and at the time of marriage, my husband was given gold and silver articles worth of rupees 5 lakhs. The expenses was nearly 25 to 26 lakhs. Marriage was done in order to fulfill the demands of my husband and his parents. Even after marriage, they used to demand me more silver and gold, failed which they used to abuse me mentally and physically. And Your Lordship, next paragraph. After
Is there any allegation? These are all before this conciliation.
Yes, Your Lordship.
Restitution of conjugal rights. Is there any allegation subsequent to that? What happened when you went back? Is there any particular incident?
Please, Your Lordship.
Is there any particular incident
Yes, Your Honor. Yes, Your Honor.
with the date and time?
In page 62, Your Lordship. That MC case reference is in the first paragraph. Subsequently, after the case, that my husband and in-law had continued to torture me, and their usual nature and taunting and using vulgar words continued. But this time my child was also victim to their torture. Every time they kept making comments as to you are not a good wife or daughter-in-law. Once in a while, whenever I made a visit to my mother place or any other festivals.
Also before this compromise.
Allah, subsequent to compromise, Your Lordship.
Huh?
Page 62.
Was referred to mediation. Mediation
Yeah,
both has
after-
agreed reunion. Accordingly, case was closed. Yes.
After the case, that my husband and in-laws had continued to torture me, and their usual nature of taunting and using vulgar words continued. But this time my child was also victim for their torture. Every time they kept making comments as to you are not a good wife or daughter-in-law. Once in a while, whenever I made a visit to my mother place for any of the festivals, I was forced from my mother-in-law to along a mother-in-law to only bring gold and silver articles in place of saris. In case if I fail to do so, I would be abused severely from my mother-in-law and family. And the next, after
Is it not a bald allegation, sir? No reference to any date, no reference to any time, no reference to any particular words.
This is the
Abusing.
demand on each and every festival which my mother-in-law is
That's why I'm
committing.
asking you, is
Therefore,
it not a bald allegation?
each and every festival allo sari tarbada in gold tomba antar helidare. This complaint has been lodged in the year 2021 subsequent to the mediation. That is happened in the year 2017. From 17 to 2021, nearly about 4 years they used to demand and force the respondent number 2 to bring a gold and saris with in
Have you
place of
given
saris.
anything?
Please, Your Worship.
Have you given anything?
ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಅದು
No.
ಗೊತ್ತಿಲ್ಲ, ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
Have you given any complaint?
This is the complaint which I have filed.
No, before that.
Before that, I have not filed.
Every festival there was a demand.
Yes, yes.
There was a harassment.
Yes, Your
Any
Worship.
complaint, any panchayat, any complaint to the
Panchayat have been
elders?
conducted. Several panchayat have been conducted
Where
in
it
the,
is
within the
stated?
family members.
Where it is stated?
ನಾನು ಬರ್ತೀನಿ ಸ್ವಾಮಿ, ಅದನ್ನ ಹೇಳ್ತೀನಿ. Next para. My father-in-law had forced me to give mutual divorce. ಅದೇ page ಅಲ್ಲಿ, last but one paragraph. My father-in-law had forced me to give mutual divorce and leave the baby back with her husband. They also cursed me and my daughter every time that we can never be happy nor lead a happy life. I will make sure you both will be on streets. And next para 63, third para, Your Worship. On 7th March 2021, there was my sister engagement. As my mother-in-law was there, spreading unnecessary rumor about my sister character, due to which I decided not to invite my husband and family to engagement, as it was performed with a few family members at our home. I had informed my in-laws family that I will be visiting my parents' place for 2 days and attended my sister engagement. But after returning back, my mother-in-law manipulated my 5-year-old daughter Shravya and collected the information about where we went and whom she met. My daughter innocently replied she attended my sister engagement. This became a very big issue at home. My mother-in-law and husband scolded me a lot over this. And other page 64, second para. My husband used to wake me up midnight, started torturing both physically and mentally. The physical and mental torture reached its peak. My husband and in-laws, in fact, told after 5 years child will go to their custody and I have to give mutual or else case will prolong for a year and thing will become more worse for me. Everyone in the family started forcing me to give mutual and let the child stay with them. They also told me my relevance is no more for this family. They themselves are forcing me to give mutual divorce. It is not my wish. They are forcing me. Mutual divorce ಕೊಟ್ಬಿಟ್ಟು ಹೋಗ್ಬಿಡು, ಮಗಳನ್ನ ಇಲ್ಲೇ ಬಿಟ್ಟು ಹೋಗು ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಕೇಳಿದೆ ನಿಮ್ಮ ಸ್ಟ್ಯಾಂಡ್ ಏನು ಅಂತ. You do not know. He has already filed a petition for divorce.
Yes, the divorce petition has been filed subsequent to the police complaint.
Correct.
Even today also, that wife is ready to go and join with the respondent, petitioner. But they are not giving an opportunity to the respondent. ನಮಗೆ ಬೇಡವೇ ಬೇಡ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, these things will repeat. Definitely it will repeat. Why you should go there?
I want my husband and my in-laws. I don't want separation, Your Lordship. They themselves forcing me to give a mutual divorce. Even today also, she will go and join with the in-laws house. She will ready to stay along with the husband.
You have not filed an petition for restitution.
I am challenging the divorce petition itself.
ಅದು contest ಮಾಡಿ. But where is your prayer for restitution? Where is your offer that I will go back and stay in the matrimonial house? After all these allegations, counter allegations, I am not only blaming the wife, of course. Is there any chance of reconciliation? Yes, there are
But in fact,
allegations.
just one more point, my lord, where I'd like to invite your lordship's kind attention. The ink page 18 of the additional paper book, what I have filed along with IA 2, 3 and memo of documents, my lord, where your lordships went through the pith and substance of the charges that I have been subscribed to by the investigation officer. My lord, at the end, your lordship will find that there is an allegation that she became pregnant for the second child and she was forced to get aborted.
Yes.
Your lordship will not find this allegation in the complaint what she has filed, which is registered in the FIR. It is something, an improvement, a fascination or an exaggeration now to impute some false allegations, my lord, and additional false allegations against these petitions.
Is there any medical record?
Yes, your lordship.
Have you produced that?
ಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ. ಏಕಂದ್ರೆ that child has been
ಅದನ್ನೆಲ್ಲ
aborted.
ಬಹಳ ಪ್ರಿಸರ್ವ್ ಮಾಡಿ ಇಟ್ಕೊಂಡಿದಿರಲ್ಲ, ಏನದು ಸೇಕ್ರೆಡ್ ಅಂತನಾ, ಕಾನ್ಫಿಡೆನ್ಶಿಯಲ್ ಅಂತನಾ?
ಅಲ್ಲ, ಅಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನಡೀತಾ ಇದೆ ಸ್ವಾಮಿ.
ಇರ್ಲಿ sir.
PW1 is
But here the petition is pending. Prima facie, you should show there is some substance in the allegation.
If she was forced to get aborted, my lord, it should have found place in the complaint. If
here what happened, even during her pregnancy, at the age of 5 months pregnancy, she forced to leave. They have not provided a proper food. She became a very weak.
Sir.
She had been to hospital.
It is my practice rather. Endless allegations are made. Husband ಗೆ ಕೇಳಿದ್ರೆ ಅವ್ರು ಒಂದ್ ದಿನ ಇಡೀ ಕತೆ ಹೇಳ್ತಾರೆ, ನಿಮಗ್ ಕೇಳಿದ್ರೆ ನೀವು 2 ದಿನ ಕತೆ ಹೇಳ್ತೀರಿ. That will not solve our problem. There must be some prima facie material. Otherwise, how to form an opinion, sir?
Definitely.
There must be something. By looking at you, according to the charge sheet, there was forcible abortion. If you could have produced some medical records to show that you got aborted, yes, I would say there is something. Supporting document is there.
Produce ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ
ಯಾಕೆ
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನಡೀತಾ ಇದೆ ಸ್ವಾಮಿ. ಹಾಗಾಗಿ